Dr. Gitali Tilak ma'am, Dr. Praniti Tilak, Trustee and HOD Department of Management, Dr. Abhijit Joshi, Acting Registrar, TMV. We have blessed to have Chief Guest, Advocate Jayant Jaybhave sir, Bar Council of India member, Dean Advocate Harshad Nimbalkar, Department of Law, Principal HOD Professor Dr. Rohini Honak ma'am. I welcome everybody. Yes, this is time for the inauguration ceremony. So we begin our program with the rich tradition of lamp lighting ceremony. To do so, I request each and everybody, all the guests, to kindly do the honor, please. It is rightly said, light is a symbol of brightness and prosperity. To make this event blessed one, to invoke Goddess Saraswati, and for seeking the choicest blessings, we have all the honorable guests over here. As we all know, Tilak Maharashtra Vidyapith was established in 1921 as an educational memorial of Honorable Lokmanya Bal Gangadhar Tilak, the father of Indian unrest and an advocate of national education. So we have offered tribute to him in his memory. I request everyone to kindly give big hands. Thank you so much. I request everyone to kindly be seated. Presence of distinguished guests on this occasion is really blessing. To set up the tone of the event, now I request Principal HOD Professor Dr. Rohini Honak, TMV Department of Law, to accord a ceremonial welcome of our esteemed guest in her address. Ma'am, over to you.
Thank you, Nayan. A very good morning, everyone. On behalf of Tilak Maharashtra Vidyapith's Lokmanya Tilak Law College, I welcome you all to this international conference on tighter legal regime for media and OTT platforms. A new milestone was created just recently with the film Coda, released on an OTT streaming platform, Apple TV, winning the Oscars, the most prestigious award coveted by filmmakers and directors all over the world. It is very evident that the OTT platforms are here to stay. This victory has paved the way for more such platforms taking over the entertainment industry for streaming new content. They are affecting the quality of our leisure time, unbridled and unharnessed by any definite legal regulations. This topic was selected precisely with these thoughts in mind. To inaugurate the conference, I wholeheartedly welcome our chief guest, Honorable Advocate Jayant Jaybhave sir, member Bar Council of India and a renowned legal professional, to grace this function. We are honored to have such a distinguished personality amidst us today, one who befits the sanctity of this conference. Sir is here because of his immense love for academics and rich experience in the legal fraternity. I extend a very warm welcome to you, sir. I express my joy in welcoming Dr. Deepak Tilak sir, the Honorable Chancellor, Tilak Maharashtra Vidyapith, and the Honorable Officiating Vice Chancellor, Dr. Gitali Tilak ma'am, who are both the inspirational and guiding force for their continuous support to all the events of our college. I am honored to welcome Dr. Praniti Tirak ma'am, who will shortly be here, Trustee and Dean, Board of Management, TMV, and Dr. Abhijit Joshi, Registrar, Tirak Maharashtra Vidyapit, who will also be gracing this occasion. I further warmly welcome and extend my wholehearted gratitude to Honorable Advocate Harshad Nimbalkar Sir, Dean, Board of Studies and Advisory Committee, Lokmanya Tilak Law College, for being a beacon of support and motivation for all the ventures that we undertake. I welcome Advocate Aniruddha Kulkarni Sir and Advocate Sunita Bansal Ma'am for their unconditional cooperation in all our activities. A very warm welcome to all the dignitaries in the audience, renowned resource persons of various technical sessions, the delegates and faculty of various colleges and institutes, and the student participants at this conference. We are looking forward to be exposed to the vast experience of these luminaries in their respective fields, who will be shedding light on the topic under consideration. It is a contemporary topic, and we hope that the deliberations and the discourse throughout the various sessions will leave us enlightened and provide us with some solutions and the path forward in respect to the legal measures to be taken to curb only the adverse impacts of overexposure to these mediums. Though a very powerful democratic tool to promote independent, responsible, healthy journalism and online OTT content, it has also proved to have a darker side and a bane to some countries like India with very little or practically no control or censorship over the cyberspace and the omnipresent hounding media. The OTT platforms, as I mentioned earlier, are definitely here to stay, and it is very true that if not regulated, then it will have a monstrous edge over the audience, but if it is censored, it will also definitely lose its edge. So I think this topic requires to be handled in a very delicate balance, leaving the OTT platforms some leeway with, of course, regulated control. OTT is yielding more unique and out-of-the-box content every day, and such original ideas are a result of the freedom of creation inherently given to every citizen under the Constitution. Thus, it becomes an inherent right of the OTT platforms too. But whether curbing and controlling that creativity will definitely hold back the extensiveness of the content on the OTT platforms, which is on the path to completely overtake conventional television within the next decade. Censorship, however, sets a dangerous precedent for limiting expression of viewpoints, both creatively and, of course, politically. One of the main concerns is whether the self-regulatory code will generate an atmosphere of fearless creativity. Will these new regulations protect producers of such well-researched and hard-hitting content, and whether this censorship will bring any relief or prove to be a bane to the service providers who are earning millions out of these OTT platforms? Possibly not. Nevertheless, we have to remember that these platforms are omnipresent and omnipotent, and having a darker side require proper regulation in order to protect the rich moral and cultural values among the youth and create a positive and healthy atmosphere and environment among the youth for the future. It is lastly also pertinent to note that these streaming platforms have business interests across the world, and India's huge population provides an enormous consumer base. Popular OTT platforms, just to mention a few, Netflix, Amazon, Prime Video, Disney Hotstar, etc., have an easy access to these, you can say, universal viewers. And the viewers have multiplied manifold further during the pandemic period. We have chosen this contemporary topic very carefully, as it touches each one of us, and none of us are really immune to the contents of the OTT world. The student community with whom the faculty and the teachers are in close contact with have noticed the impact of these platforms on the youth and how in several cases it has led to valuable youth resource of the nation being led astray on the path of antisocial activities and even criminality. Behavioral changes have been systematically noticed in the youth, leading to severe long-term influences on their behavior and formulation of ideologies, and the way of thinking having adverse ramifications for the society. The academic performance of the students has definitely suffered. In the light of all these various issues and the strong people's movement our nation is witnessing today, we are looking forward to the academia expressing their opinions on the themes in a structured manner. I appreciate all the efforts of the faculty coordinators, Assistant Professor Rucha Shinde and Assistant Professor Ashwini Biradar, along with the student coordinators and volunteers for their meticulous organization and planning of this conference. All the other faculty members and administrative staff, they have also strived hard for the smooth execution of the program and are also appreciated. Before concluding, my mind is drawn to a wise quote which seems aptly describing the significance of this issue today. Technological progress is like an axe in the hands of pathological criminals. Hence, have we already opened Pandora's box and let out self-created Frankenstein's monster is the question that is going to be pondered throughout the day. I once again welcome all the dignitaries, the delegates and the audience, and I hope that you will have a very rewarding and enriching experience throughout all the sessions. Once again, I welcome you all. Thank you.
Thank you so much, ma'am, for enlightening us with your thoughts. Now it's time for felicitation. We are really privileged to honor our special guest, Advocate Jayant Jaibhave sir. To do so, I will now request Honorable Officiating Vice Chancellor, Dr. Gitali Tilak ma'am, to kindly do the honor. Can we have the huge round of applause, please? To talk more about Sir, he has not only benchmarked his achievements with the quality of work, but is truly the treasure asset. Sir, you have achieved an incredible milestone and you surely deserve the spotlight today. This is also a celebrating moment for all of us because he has been assigned a member of Bar Council of India. Many congratulations, sir. We will now felicitate Honorable Chancellor of TMV, Dr. Deepak Tilak, sir. We are honored by your kind gesture, sir. I request Principal Ma'am to kindly felicitate Dr. Deepak Tilak, our Honorable Chancellor. I request all the students to kindly keep clapping. I would request ma'am to felicitate Honorable Officiating Vice Chancellor Dr. Gitali Tilak ma'am. Thank you so much ma'am for your stewardship, vision and continued support. We will now felicitate Advocate Harshad Nimbalkar sir, Dean, Law Department. Harshad Nimbalkar sir. Thank you. I request everyone to kindly be seated. Without further ado, we will begin our session. I would now request Assistant Professor Shaista Sheikh ma'am to kindly introduce our Honorable Chancellor, Dr. Deepak Tilak sir. Over to you, ma'am. All right, I will request now Assistant Professor Shaista Sheikh ma'am to kindly introduce our Honorable Officiating Vice Chancellor, Dr. Geetali Tilak ma'am. Welcome ma'am.
A very good morning to all the dignitaries on the dais, our honorable resource persons who are present online, and my dear students. I, Assistant Professor Shaista Sheikh, is privileged and honored to introduce a woman of virtue and simplicity, Dr. Geetali Tilak ma'am, Vice Chancellor of Tilak Maharashtra Vidyapit, a Professor of Mass Communication and Dean Faculty of Modern Sciences and Professional Skills. As an eminent academician, she carries 2 doctoral degrees in the field of management and journalism. She is also the recipient of a prestigious D.Lit degree. Dr. Geetali Tilak ma'am imbibed the zeal for imparting education from her great-great-grandfather and freedom fighter Shri Lokmanya Bal Gangadhar Tilak, and continued the legacy to support her father, Honorable Dr. Deepak Tilak sir, Chancellor of Tilak Maharashtra Vidyapit. For her valuable contribution in the field of education, Dr. Geetali Tilak ma'am has received many prestigious awards. To name a few, the Best Young Dean of the Year Award, International Academic and Research Excellence Award by the Venus International Foundation, Utkrishta Grantha Nirmiti Puraskar, reputable Dr. APJ Abdul Kalam Sadbhavana Award, and many more. Dr. Geetali Tilak ma'am's research work can be seen in various publications like the Newspaper Management, New Social Media, Ethics and Laws in Media, Sarvansati Ekbana, Swarajya is My Birthright, Media Management, Event Management, and many research papers are published in various national and international journals. Dr. Geetali Tilak ma'am carries 3 copyrights on her credit. Dr. Geetali Tilak ma'am has been actively engaged as a director of the Sports Committee, coordinator of the NAC Committee since the year 2009, a teacher of ever-trending courses like Judo and Ekbana. Additionally, she has also been a member of several important committees and boards of committees of the Vidyapit since the year 2013. She is a member of Research Committee, MIT University, Pune Kennel Club, Ved Shastro-Tijak Sabha, and Pune Judo Association. She also holds the proprietorship of the Indutai Tilak Kala Kendra under the name of a grandmother, Indutai Tilak, a renowned educationist and a social worker. Her passion and energy seems to know no bounds. She is a dynamic and compassionate with definite beliefs and cheering our Tilak Maharashtra Vidyapit towards new horizons. I request you, Dr. Geetali Tilak ma'am, to share your few valuable words with us. Over to you, ma'am. Thank you.
Thank you, Shaista. Honorable Chancellor Dr. Deepak Tilak, Chief Guest for today, Advocate Jain Jaibhavi sir, Dean Dr. Nimbalkar, Head of the Department Dr. Rohini Hona, speakers, participants, faculty members and dear students. A very good morning to all of you for this one-day international conference on title like Legal Regime for Media and OTT Platforms. Being a media person, as she introduced me, I'm more keen on this conference today because I have been working in this media industry for past 19 years.
and of course in the print media. But as you know that this Vidyapeeth is in the name of Lokmanya Bal Gangadhar Tilak, who was a strong promoter of national education. We started with the print media in 2000. So what exactly was the idea is like Lokmanya Tilak almost used every medium to reach the masses. Not only just Kesari or Maratha newspapers, but he used theatres, films, dramas, then all other, even he had contact with different artists, painters. So each and every medium was touched with him to reach the masses. So you know that how, this field is so dynamic and also so much like the what you can say, the audience are totally attracted towards it and they are totally believe in media. So print media was the authentic one earlier, so we started with those courses, but slowly then as you see that this field is dynamic, we started with other mass communication courses like filmmaking and then broadcast and television journalism. So seeing this technological advancement, this then comes the OTT platform since a very long time now. So this conference is related to it. So in media angle, what I feel is when I did my PhD in journalism, it was on children's magazine. Just to give you an example, so when I went through the editors, I got to know one thing, that they never studied what the audience really want, what the children really are developed with. They just started with writing the content for the children and started distributing the supplements. So what happened is they never understood what development is happening in the kids. So that when I became the editor of this kids magazine Jhava, I got to know this, that nobody has ever studied this. That made me do this PhD and research. The idea behind telling you all this is, when I am being a professor and head of the Department of Mass Communication, I got to know this, that we lack in understanding the media psychology. What exactly impact does it do to the audience? Because finally all these platforms, all these mediums are for the audience. So when you don't understand their psychology, you may not know, because the content writer, the creators, because you see the media people are writing on different platforms, may it be print media, television media, for films, even for sound. So you just guess, like even if you hear a song, what impact or what perception you make about that person without knowing what was his intention being doing that. So then we included this media psychology or this psychology part in the curriculum, just to understand that before creating the content, what should be kept in mind. Like if you have read about Lokmanya Tilak, even he had, everybody has written many articles regarding one thing of his, that is regarding the child marriage. So there are both negative and positive articles which we have read about him. Few say that he used to support it. Few said that yes, he didn't oppose this child marriage. But that was not his idea behind what he was saying. Nobody actually understood. I mean, those who are writing negative about it, they never understood his idea behind telling it. What he meant was that imposing law, I understand law needs to be imposed on the public for certain reasons. But before, are they able to understand why is this rule made for them? Because that was the difference. He was not against child marriage, but if you impose without telling the people why exactly this child marriage act is there, they won't know why should we follow it. If that is a human tendency, if you ask them to do something, sit on their head, say do it, half of them will revolt back. So that's what I wanted to emphasis over here, that before educating the people about what they want, what is good for them, you directly impose laws on them, due to which there are a lot of controversies happening everywhere. Like a few articles which I went through, like according to the recent forecast, the Indian video OTT industry is expected to reach 1.7 billion by 2023. And India is also expected to become the 6th largest OTT market by 2024. Some of the factors which fueling this aggressive growth are higher disposable incomes, the growing penetration of smartphones and devices, and a burgeoning demand for quality OTT content in India. COVID-19 also proved to be a game changer, as most of them were at home, so they switched to this OTT and free internet. However, despite the optimistic look of the Indian video OTT industry, the government recently announced new guidelines that may prove a damper for streaming platforms. The proposed three-tier mechanism called the Information Technology and Digital Media Ethics Code Rules 2021 aims to regulate OTT video streaming platforms, social media channels and digital content providers and make them more accountable within the Indian legal landscape. It should be noted that one of the key reasons for regulating these platforms is to ensure parental locks are implemented for content that is not appropriate for the children. In all the chaos surrounding the controversies, the bigger worry is if by regulating OTT, the government is curtailing the creative freedom of the content makers. Now, being a media person, I am emphasizing on this because will the moral policing of such show rob the platform of its differentiating factor? Whatever you see on the television or in the films, if you repeat the same things on the OTT platforms, will they affect the viewership of it? Is what is concerning. So that is what they wanted. Yes, it is needed to have laws in it, but to what extent? So that's why I feel that the media schools or the content creators should be educated about what is hampering the audience, because finally we are making the content for the audience. Because now when you see few of the channels you feel we shouldn't watch with our kids or with our children, because we feel that this content is not appropriate, but the person who is putting it has some other things in his head, so he doesn't realize that which audience he is targeting. So that's the lacuna which I feel in media people who are unable to understand. Secondly, what I would like to say is all this raises the question, what role does the consumer play in this success of OTT platforms? Since consumer engagement is vital to the OTT model, stringent regulation could interfere with the type of content and users want to consume and therefore hamper the growth of the industry. So regulated OTT content could also imply missed opportunities for filmmakers and actors who are lured to the medium for the creative freedom it offers. The OTT platforms will be required to follow the basic laws of the land while streaming the content, which I mentioned. Many of the OTT platforms signed a self-regulatory code, the Code of Best Practices for Online Curated Content Providers, which was released by the Internet and Mobile Association of India, IAMAI. So I am happy that Tirak Maharashtra Vidyapeeth Law College has organized this conference, because this one-day conference gives an aim of giving a platform to the young generation, participants coming up with their ideas, beliefs, knowledge and boosting their confidence so as to fulfill Lokmanya Tilak's dream of national education for providing equal opportunities for the development of human potential of every segment of the society. I hope that through this conference there will be a great learning, sharing insights and views will definitely help us to move in the right direction. I once again welcome, congratulate and wish you best luck for this conference. Thank you.
Thank you so much, Geetali ma'am, for your priceless insights and sharing your valuable thoughts with us. Now I request Assistant Professor Rohan Bawdekar to introduce our next resource guest, Advocate Harshad Nimbalkar sir, Dean, Law Department. Over to you, sir.
Namaskaram. Good morning, everyone. I, Assistant Professor Rohan Bawdekar, feel privileged and honored to introduce our Dean, Advocate Harshad Nimbalkar sir. Sir has completed his bachelor's degree in science along with bachelor's degree in law, as well as pursued diploma in business management. He is a renowned lawyer, practicing since 1984 in district and session courts, Pune. He specializes in criminal matters and has appeared for more than 3,000 cases in various session courts. Sir has been appointed as a special public prosecutor by the state government in various cases at Pune, Ahmednagar and Aurangabad. Sir has appeared and argued before the Supreme Court of India and High Courts in Maharashtra and Delhi, and was also appointed as amicus curiae by the Supreme Court in the appeal and confirmation matter of General Vaidya murder case, wherein Sir's performance was specially appreciated by Supreme Court of India. He has served as a Vice President of Pune Bar Association in 1991 and as the President in 2001. Sir was elected as a member to the Bar Council of Maharashtra and Goa from 2004 to 2009. He was then elected as Chairman of Bar Council of Maharashtra and Goa twice. Sir is the first person after late Ramrao Adik who was re-elected as a chairman for the second time. In his tenure as a chairman, Sir has organized many state-level conferences and legal education programs. Sir was invited by Bombay High Court to deliver lectures and guide ad hoc district and session judges in 2003-2004. Being an expert in the field of law, Sir has been invited to deliver guest lectures on various topics in law and medical jurisprudence in Symbiosis, Deccan Education Society, ILS Law Colleges, Bharati Vidyapit, Yashwantrao Savan Law College and other important institutions. We are very happy to have you here with us today, sir. Now, I would like to invite Advocate Harshad Nimbalkar, sir, to share his valuable thoughts with us. Over to you, sir.
Honorable Chancellor of the Tirak Maharashtra Vidyapit, Dr. Deepak Tirak, Honorable Vice Chancellor, Srimati Tirak Madam, the chief guest of today's function, Sri Jayan Zaibave, Member of the Bar Council of India, the Honorable Principal of the Tirak Law College, Dr. Honap, my colleague in the Board of Studies, Advocate Kulkarni, Shri Khadilkar, all other teaching faculty, and students, participants, ladies and gentlemen. It gives me immense pleasure to be with all of you this morning for the inaugural function of this international conference on a very new but a very important topic of the future, that is OTT platforms. We have started this college in 2012. Initially we had moot court competitions, the state level moot court competitions. Then we started the moot court competitions at the national level. These competitions were very successful. This year we have also started an elocution competition in the name of Honorable Jayavantrao Tirak. And this international conference we have started from last year. And the last year, of course, we had to do it online. But this year we are privileged to have this conference physically. Friends, as has already been spoken to by Dr. Honap and Dr. Geetali Tirak Madam, this OTT platform, initially, as all of you know, there were no regulations, there were no laws so far as these social platforms and OTT platforms are concerned. These OTT platforms are on the rise. There are a number of OTT platforms like Netflix, Amazon, Hotstar, so on and so forth. And this is going to increase by the day. And India is one of the prime consumers so far as these OTT platforms are concerned. And due to the pandemic, these OTT platforms are on the rise, and the viewership was on the rise during this pandemic times. And therefore, there is a need to have proper laws in respect of these OTT platforms, proper regulations for these OTT platforms. Of course, there are arguments from both the sides. Initially, as you know, there were no laws, but in 2021, the government, especially the Information and Technology Ministry, have come out with these rules, Information and Technology Rules 2021, under the Information and Technology Act of 2000. And there are a number of regulations now in respect of these platforms. They have now introduced the three-tier grievance redressal forum, in which if there are any complaints, if there are any grievances, that can be taken care of, and that those grievances can be redressed through this three-tier system. In fact, in the second tier, it is also said that retired judge of the Supreme Court, retired judge of the High Court, and eminent personality from that occasion would be dealing with these grievances, and therefore the government is trying its bit to deal with this kind of grievances in respect of these OTT platforms. The concern is about the content, because there are some complaints which have already been filed in the High Court, even in the Supreme Court, in respect of the contents, because as there was no censorship to these OTT platforms, it is argued that these various contents which are being streamed, there are problems in respect, say, religious sentiments of persons are, there is impact on the religious sentiments, then there is also defamation, the language used is vulgar, and obscenity is also there, and therefore there should be some control in respect of the streaming of these platforms. On the other hand, there is also argument to the extent that after all the country is growing and we are now moving towards a developing nation, and therefore whether there should be restrictions, because in a progressive society people should also be able to watch what they want to watch, and therefore how much restriction can be imposed. So both the side arguments are there, and it is only through these conferences that the things can be discussed, the issues can be discussed, it can be debated, and therefore proper solutions can evolve. Of course, the rules also say that there should be categories for viewership. It should be universal. Some content should be universally viewed. Some should be viewed by children below 7 years of age. Some should be viewed by children below 13 years of age, below 16 years of age, and there should be different content for adults. And therefore, now all this should be regulated, and it would be definitely regulated in due course of time. But I feel that so far as the various contents are concerned, it should be for different categories, and therefore proper law should come into effect so that it should be channelized in a proper manner. They have come out with the rules, but then there are not adequate laws in existence at the moment, and therefore proper laws governing these OTT platforms and the contents are necessary for a democratic society. Of course, all this will be discussed today, and therefore everyone will be benefited through these discussions, etc. Friends, we are very fortunate to have Advocate Jayant Jaibhave in our midst this morning as the chief guest for today's inaugural function. Advocate Jaibhave is in fact the backbone of the State Bar Council, and Dr. Honab said that he is an academician. I would say that he is academician to the core. In fact, it is through his efforts that the Bar Council is conducting number of programs for the benefit of young lawyers who have entered the profession. When he became chairman in 2010, since then he started this continuous legal education programs continuously throughout the year, and the junior advocates really benefited from this. Various senior advocates, judges, retired judges as well as acting judges gave lectures and training to these junior advocates who have really benefited. Not only that, but thereafter, when the former Chief Justice of Bombay High Court, Justice Mohit Shah, lamented that we are not getting good judges at the ground level, at the JMFC level, Jayan Zaibave came up with a very new idea, and that idea was that we should start a program, training program for junior advocates who want to become judges, and therefore we started this judicial service as a career, and this program also became very popular. Not only that, but we could contribute to the judicial system by giving number of judges through our training program, that is judicial service as a career. And now we are together in the Bar Council since 2004, and now in this term, when we started this term of the Bar Council in 2019, he came with a new unique idea of starting a program called BLEP, that is Basic Legal Education Program, for the new entrants in the legal profession. The advocates who just get their sanat, they become lawyers and get their sanat. For them now we have started this Basic Legal Education Program. He has himself taken pains to prepare this curriculum, and we are now giving training compulsorily to this new entrance in the legal profession, because as we know, practical experience is totally different from the training given in law colleges, especially in the field of law. After one becomes advocate, he's not knowing anything about the procedure and practice in the courts, and therefore this training program is very essential for the new entrants in the legal profession. Otherwise they get frustrated and 2-3 years are wasted in just following the seniors or just writing applications for adjournment, so on and so forth. And therefore this new program, Basic Legal Education Program, is definitely helping this new entrance to the legal profession. Zaibave is having a very busy schedule. In fact, he has reached today morning at 4 o'clock in Pune, because he was engaged in 2 functions at Shahapur and then at Thane in the evening. And in spite of his busy schedule, he has found time, and therefore we are thankful to him for his presence. With this, I take your leave. Thank you.
Thank you so much, sir, for sharing your words of wisdom. Moving ahead, I now request Assistant Professor Ramnit Arora ma'am to kindly introduce our chief guest, Advocate Jayant Jaybhave sir.
Thank you, Nayan. Good morning to the dignitaries on the dais, my colleagues, participants, and my dear students. I, Assistant Professor Ramneet Kaur Arora, take immense pleasure to introduce our guest of honor, Advocate Jayant Jaybhave sir. Being in the field of law, sir holds a bachelor's degree in physics along with law and has completed his diploma in cyber law, alternate dispute resolution, and intellectual property rights. Sir, from the inception of his career, has been a practicing advocate and has his firm in the name of Advocate D.T. Jaybhave and Associates, with over 15 associates at Nasik in Mumbai. From the last 35 years, Sir's experience lie in the field of civil, revenue, land acquisition, criminal, arbitration, consumer, cyber, matrimonial, and banking matters. Sir was a member of Maharashtra State Law Commission along with Bar Council of Maharashtra and Goa. He has served as a chairman in the year 2010-2011 and vice chairman in the year 2008-2009 for Bar Council of Maharashtra and Goa. And during his tenure in the Law Commission, he was a party to preparation of 26 law research reports submitted to the state government. And as of now, Sir is also elected as a member of Bar Council of India. Not only is he a distinguished lawyer, but also excels in academic field. He has published books such as Civil Pleadings, Conveyancing and Drafting, CPC Approach to Civil Trial, Evidence Act Approach to Civil Trial, Marathi books on CPC, and many more, which are referred by many budding advocates and judicial service aspirants. Today, being an excellent academician, even in the pandemic, could not stop him from guiding the young professionals. He, during the unavailability of resources, helped the students by conducting webinars which are available on YouTube and articles available on various resources. Sir not only has excelled in his profession in academics, but has also worked for the welfare of the legal profession by starting the first computer law library in India at Nasik and subsequently established computer law libraries throughout the state of Maharashtra. He innovated national level moot trial competition and initiated programs such as Continuous Legal Education Program, Judicial Services Career, Mediation Awareness Program, and Prosecutorship as Career. He has also worked as a panel judge in about 125 different Lok Adalats and worked for the promotion of Marathi language in functioning of judicial system at trial in High Court, Mumbai. It is an honor to have such an eminent personality with us today. We welcome you, sir. I would now like to call upon sir and request him to share his thoughts.
Respected Chancellor, respected Vice Chancellor, Honorable Head of the Department, Madam, Dean of the College, and my close friend, Advocate Harshad Nimbalkar, former Chairman of the Bar Council, all the faculty members and the dear students of law. It's my immense pleasure that today I had an opportunity to speak before you in this college, which is in the name of a person who was not a person who gave the momentum to the freedom fight of the country, but as a law student and as a practicing advocate, we must understand that Lokmanya Tilak was a person who was having an inherent qualities of justice in his own personality, which he exhibited in his throughout life. And therefore, while participating in this international seminar on the laws relating to OTT, first I take this opportunity to salute the great personality, Lokmanya Tilak, and also to give my all best wishes to the University, Tilak Maharashtra Vidyapit, and also the Law College in the name of Lokmanya Tilak. I have given many speeches, right from the school time to the international conferences. And I still remember, Harshadji, my first speech, which was on Lokmanya Tilak. And you all law students living in Maharashtra should learn his personality, because my first speech was on one incident of the life of a Tilak when he was a small boy. In Marathi, you must be knowing that story. मी शेंगा खाल्ल्या नाही, मी टरफल उचलणार नाही. You know this story of Lokmanya?
Yes, sir.
It was a reflection of his personality, one thing. But this is an inherent quality for the justice. मी शेंगा खाल्ल्या नाही, मी टरफळ उचलणार नाही. दिस वॉज नॉट ओनली वन रिॲक्शन ऑफ द पर्सनॅलिटी. It was his inherent quality as a man with a sense of justice in his entire personality. We must try to learn. Whatever law we are studying, whatever law discussions we are doing, everything is for the justice. Law is for justice, procedure is for justice, making of a law is for justice, everything is for justice. Because behind all laws, there is a jurisprudence. And jurisprudence ultimately takes you towards the justice. And therefore, we must learn all these personalities. A second example relating to the today's topic. Today's topic is of OTT platforms and required laws. We'll discuss that. I'm not an expert person on that technical aspect of the OTT. But on a law-making process, I will be definitely talking with you on execution of a law and what is the role of a lawyer and a judge in this entire process of a law-making and as well as in an entire process of law execution. That definitely I will try to put some few part of my speech. There was one case against Lokmanya Tilak, and that was relating to the today's topic. Today's topic, on which basic principle today's topic is related, we will have a dialogue, friends. Making a lecture of 45 minutes or 30 minutes many times makes all of us a boring situation. So let us have a dialogue, which is a basic principle on which we will be discussing the entire seminar. Laws are to be created upon the OTT, upon the expressions in the OTT, their contents, their morality, decency. Which basic law we are going to talk about this? Anyone?
Media law.
Fundamental rights. Media law. Yes?
Fundamental rights.
Which fundamental right?
Freedom of speech and expression.
Freedom of? Correct. Freedom of expression. This is the basic right. Law can be made. The law must be concurrent to which basic law of this country? Constitution of India. And in the Constitution of India, there is a freedom of speech. Which article? 19. Article 19. So we are going to talk about the making of a law which will be governed ultimately by Article 19. Because friends, any law can be made in this country. If it is exceeding to the basic principle of the Constitution, it may be the fundamental rights, it may be a directive principles, it may be any other substantial provisions of the law of the Constitution. What is an ultimate effect? If a law exceeding the Constitution is made, what is an ultimate effect? What will be the fate of that particular law? You must have read as a law student. You have heard about the ultra virus to the Constitution. So anything should be within the framework of the Constitution. So Article 19 is there. 19(1) that says that there is a freedom of expression. And against that, is there any provision to control this right in a Constitution? Is there right? Which provision? Yes, Article 19(2). Article 19(1) talks about a complete freedom of speech. Under Article 19(2), there is also a reasonable restriction for this freedom of speech. Freedom of speech is there. But because you have a certain freedom of speech, you can't make such a speeches whereby there will be a disturbance to the public health, there will be a disturbance to the society, there will be a defamation of any individual, and there will be such a consequences which will be attracting to the other provisions of the law. So that reasonable restriction is permissible under Article 19, subclause 2. Lokmanya Tilak wrote one article. You know that in a paper Keshri, we are talking about the freedom of expression. He wrote one article. You know what is that article? सरकारचं डोकं ठिकाणावर आहे का? What was the fate of that article? He was prosecuted. He was convicted. Correct? 6 years to the Mandale. You visit Bombay High Court. And in that Bombay High Court, there is one room number 46, which is a principal court of a Bombay High Court. And in that principal court, nowadays, oath is given, functions are conducted in respect of the Bombay High Court. Outside of this room number 46, whenever you will go, you will find that there is one marble stone with carving of certain letters there. These letters are the words spoken by Lokmanya Tilak to the judge after his conviction in this case. He has spoken about the right of expression. And he has spoken that this is my duty for getting a freedom of this country, which is a larger interest of the public at large. Whether government is harmed or government is not harmed, I am not concerned, because I am with the cause of freedom. And for that particular cause, my right of expression I am using, and this jury might have held me guilty. But I know still there is one destiny where there is a understanding that I am not guilty, because whatever I have done in the interest of the citizens of my nation, public at large, and in the heart of that destiny, I am innocent. To this extent that words are there, which are there permanently put in a marble stone with the carving words on room number 46. You go to High Court, Bombay High Court, whenever there is an opportunity for it. You go to High Court or not? Yes, to go there, room number 46. You are studying in a Tilak Maharashtra Vidyapit. So the principle of justice is incorporated there, and that was on the basis of that particular article relating to Article 19. At that time it was not Article 19, the Constitution was not enacted, but it was a basic principle of a freedom of expression which Lokmanya Tilak has said there. Friends, on today's topic, two important words Honorable Vice Chancellor has spoken here. One, she said that need. We are discussing today the law relating to the OTT. She said that need. Because need is the base for creation of any new law also, any innovations also, and any research also. In Marathi we call that गरज ही शोधाची जननी आहे. आज गरज निर्माण झालेली आहे का? That is a question which we are discussing today. Whether OTT and the law relating to the OTT is a requirement, and whether that requirement is to be converted into the law, and which type of a law. That is a point of discussion which we are discussing. And secondly, she also said about the consumer. Second word, consumer. That is also a relevant aspect of the today's discussion, because we may compare this entire activity of OTT with television, with cinema, with radio. There is a basic difference. And that difference is that the release, broadcast is of television, radios. OTT is not a broadcast, because a broadcast is a public activity. It is in a public domain. It is open for all. There was one time in particularly 1950 to 1975, when there was also license to the radios, there was also license for the televisions. Do you know these things? You are now the younger generation of this, after this 90. So before 90, there was also the license period for the televisions and the radios. If you have to purchase a radio, you have to purchase a license probably from a post office. That license was used to be issued, and then only you can have a connection of the radio. That was a particular time. It was a public domain. Radio, television, whatever the broadcast was there, it was on a public domain. Movies. The picture was shoot. The script was given, and even today that procedure is there. The censor board, they censor, they verify, and they add, delete, and then they give a permission. Censor. We are talking about the censorship also today. And if you see the definition of the word, simple word censor, because of, as a lawyer and as a law student, whenever you are talking of some words, you should be with a full habit that you should have a complete meaning of that particular word. If you are talking about the censorship, you should have an understanding what is meant by censor, what is meant by censorship. A simple meaning of a censorship is an authorization to verify, to add, to delete, or to reject a particular publication. A simple meaning. So censorship. Now, if you are talking about the censorship to the OTT platforms, we'll have to verify whether it is a broadcasting, whether it is on a public domain. Because law must be logical, law must be appreciable to the common man, and ultimately law must be within the four corners of the Constitution. So the first argument which will be there, we'll discuss it, will be that it is not a public domain. It is not a broadcast. OTT is a paid facility. As you go to the market and purchase something, food for you, as you go to the market and purchase something for your own drinking, or like that, for your personal consumptions, as a personal need as a consumer. But madam termed it as a consumer need. As a consumer, you will be making the subscriptions, and because of that the subscriptions, you will be having a link via internet to the OTT platforms, and then we will have to give a consideration of a censorship to this particular activity of a OTT. Then only it will be tenable at the eyes of the law, and then it will be attracted under Article 19(2). If we want to restrict all these activities, if we want to create a censorship on this OTT activity, we will have to show that this is a reasonable restrictions on this freedom of speech, freedom of expression, not only speech, freedom of expression. Ways of expressions are many others which she referred. It can be words, it can be sound, it can be music, it can be any symbols, many things. As a lawyer, I will refer this aspect to you, like consider the definition of a document in a law, in an Evidence Act. What is meant by document? If at all this OTT is to be controlled by any Indian laws, under the Indian various different laws, we'll have to consider that this will be again one document as defined under the Evidence Act, which includes anything, words, spoken or written, any expressions, any marks, anything which is expected by third party to be read or heard, that can be said to be the term document. And therefore in this particular context, if these particular three words which madam used in her speech are properly understood, what is the need, whether we are a consumer, we are considering the control of the consumer need, and whether that consumer needs control can be controlled under Article 19(2) within the framework of reasonable restrictions. Definitely within these 3-4 corners we can make the law. She has also spoken about something about media psychology. It is a different concept, and moreover this particular all types of concept nowadays are related to the social footings, what people expect. There was one time when news were given in a particular manner. I don't know whether you have gone through that old news. It was a complete, in a Marathi, plain Marathi, we can say that a complete blank face. The news reader was supposed to only give the facts. हे असं झालेलं आहे, ते तसं झालेलं आहे, ते अमुक झालेलं आहे, ते तमुक झालेलं आहे. This was a style. Media psychology, she talked something now. Now what is a media? What is a news? That Arnav Goswami, I think, no? His case, you know that what happens. India chahti hai. Nation want. As if he's throwing some stone on the viewers. If you get a feeling like that. So these types of the psychology from that entire blank face of putting facts before the consumer or before these viewers, now something is thrown, attacked, and different type of a media psychology is there. Whether a control is required here. Again, so both way, whether it is need of the hour, and because of that need, if a laws are made, whether that laws will create an encroachment on the freedom of expression, in both angles, this particular topics is required to be discussed, friends. I'll come to that technical aspect, but before that, when we are talking of the law, you must understand as a law student what is the process of making of the law. Because we are the executant of the law. You know there are 3 pillars of the constitution. One is the law making body, another is the law executor, and another is the bureaucracy. Also the media is said to be the 4th untold and nowadays uncalled pillar of the democracy. So these are the pillars of the democracy. They are supposed to work independently, parallel to each other, without interfering each other's region. So lawmaking is a process whereby in a democracy, considering the need of the citizens, that need is always a public need. It cannot be an individual need. But of course, if it is a consumer, even there is a law relating to the consumers. What should be sold, what should not be sold, what should be the quality, what should be the quality control. This is there. No, so many laws are made for the consumers. And therefore, this particular making of the law, it goes with the need of the society. Basically, what is law? Law is the rules and regulations mainly made to maintain the peace and tranquility in a society. You are all Maharashtrian, and I will suggest you just read the thoughts of Shivaji Maharaj on the law. Kaida manje काय? And if you are bothered to read Marathi book, I will tell that see one movie. थोरातांची कमळा की मंजुळा. That picture आहे. Then there is one Marathi picture. आणि तो तुम्ही बघा. The basic theme is what is law? कायदा म्हणजे काय? याच्यावरचं शिवाजी महाराजांच्या त्या काळामध्ये झालेलं संभाषण एक 15 मिनिटाचं आहे. And dialogue is between 2 kings. Because king is above all law. पूर्वी असं होतं, आता नाही राहिलेलं. पण the king, Shivaji Maharaj, and another tomorrow's king, Sambhaji Maharaj, there is a fight of a dialogue between these 2 personalities. To understand what is law, one must see that, at least in a Maharashtra. And when some crime has been done by Sambhaji Maharaj, he has been prosecuted by Shivaji Maharaj by filing a complaint himself. And there is a dialogue. So Sambhaji Maharaj asked Shivaji Maharaj how king can be prosecuted and how the law can be above king. कायदा राजापेक्षा मोठा असतो का? So Shivaji Maharaj has replied him, कायदा म्हणजे समाजातल्या 4 जाणत्या लोकांनी समाजाचं नियमन करून समाज स्वास्थ्य राखण्याकरता केलेले नियम असतात. That is the definition. That is the definition of the law. Nothing else. It is so simple, friends. And therefore, when you come to the interpretation of the law, the teachers tells you the law is nothing but logic. Logic is nothing but common sense. And common sense means what? The sense which is appreciated by your own heart. That is a common sense. तुमच्या मनाला एखादी गोष्ट पटली पाहिजे, नाही अरे हे बरोबर आहे. Because every individual has a great quality of having an inherent quality of a justice. प्रत्येकाला असं वाटत असतं की हे सगळं नियमाप्रमाणे झालेलं असलं पाहिजे, कायद्याप्रमाणे झालेलं असलं पाहिजे. That is everybody's general feeling. Unless a very defective character is there, you want everything to be against the law. But when you read jurisprudence, you will find out one line of a jurisprudence. This is correct that when you think about people at large, every good individual feel that it should be by law, it should be not an irregular, there should not be any injustice. Whenever jurisprudence says that, it's not my opinion. Jurisprudence says that whenever it comes to an individual, jurisprudence has said individual is always against the rule of the law. Individual is always against the rule of the law. इतरांनी काही वाईट साईड पाहू नये हे सगळ्यांना वाटतं. मला पाहता आलेलं तर जमलं पाहिजे. This is the psychology of a human being which has been recognized by the jurisprudence. The question is that when we are willing to make a law on such a thing, OTT platforms, where mobile is in a hand of 40 or 30 or 50 crores of the citizen of this country, out of that 50% may not be properly educated, 50% may be educated. Recent statistic madam has given, what I have read, there is a viewers, after corona there is a viewers of 17 crores for these OTT platforms, and there is an annual increase of 21.8% annually in this viewership. So all these citizens with a huge number, with huge variety, with huge culture, with huge ideologies, with different languages, are susceptible to these OTT platforms. The question is that whether law will be sufficient, which law can be made, what type of censorship can be made, and whether making of that censorship will be sufficient. This is the question which we as a law student must discuss. Because I was talking about the law making process as I was a member of a law commission for a long 12 years. I have seen it very carefully. Qaida Mandal should do the law. Maharashtra Legislative Councils, Parliament, Rajya Sabha, these are the law making bodies. They should do the law. What is the real discussions in the platforms about all these situations? And I try to find out the percentage of discussions. It is very few. In fact, they are supposed to work more than 90% on a law making process. कशासाठी पाठवतो खासदार आमदार निवडून? कायदा बनवण्याकरता. They are the lawmakers. They are supposed to discuss on a law, making of the law. And the statistic shows that in a parliament, in a Lok Sabha, there is a 9% working on law making process. In a Rajya Sabha, there is a 11% working on a law making process. In a assemblies, various assemblies, there is not more than 4%, 5% working. If 100 hours are worked, out of that 4 hours, 5 hours are worked for the law making process. बाकीचे वेळ करतात काय ते टीव्हीवर कधी कधी आपल्याला दिसतं. They are the lawmakers. They want to understand all these things. So what to do? आपण हातावर हात ठेवून बसू शकत नाही. Therefore, your attempt, madam, is appreciable that you are taking this subject and you are discussing it. And therefore, when all the younger generation who are learning the law will contribute on this particular subject, they should understand what is the law making process. They should not have a concept of a fantasies in their mind. Because young generation may have some fantasy. हे असं का नाही होत, ते तसं झालं पाहिजे, हा अमुक कायदा झाला पाहिजे, ते तमुक झालं पाहिजे. It's not so easy. This is the entire law making process, friends. आपण जे काही चर्चा करतो, ज्या काही डायलॉग करतो, त्याच्यामधनं काहीतरी निष्पन्न झालं पाहिजे. There should be an outcome of that particular discussion. For that, you should understand what is the Constitution, what is an Article 19(1), what is an Article 19(2). Which are the methods of making of the law? आपण उद्या एक या in this particular international seminar, suppose we made one particular resolution that yes, this types of law is there. Solve that. We will discuss. Legally we will discuss. The speakers, eminent speakers will put their thoughts, and that particular resolution is sent to the government. It will be considered, friends. And today they have called Bar Council here. You are going to be the members of a Bar Council tomorrow. It is the role of a Bar Council to initiate such types of making of the law, changes of the law in accordance to the Advocate Act 1961. The State Bar Council function in accordance to the Section 6 that you should discuss the law, you should suggest the changes. This Bar Council of India, of which I am a member, they functions as per Section 7, and therefore the main role of a Bar Council of India is also to represent a parliamentary committee and suggest before them that these laws are required. These inputs are required to be given to the parliament and all other law-making bodies, and out of that, the bureaucracy will prepare the notes for discussions in the house, and out of that discussions, law will be made. This should be the process of making of the law, which you should understand. It is not that somebody, Prime Minister, decides that this law is to be made. It's all right. That is one of the way. But the public opinions and public domain, and particularly on this topic, I am sure the younger generation views, and particularly the views of the law students, younger generation of the law students will be very important. Otherwise, we are not doing our duty as a citizen, as a law student, as an advocate, as a Bar Council members, and as an institution like a Bar Council. We should do that. Otherwise, all this law-making process has gone in the hands of the bureaucracy. I have closely seen that. अर्षदराव एकदा शिर्डीचा कायदा बनवा अशी लॉ कमिशनला आमच्याकडे डिमांड आली. आम्ही म्हटलं चला लेट अस डिस्कस व्हॉट इज द नीड ऑफ अ शिर्डी अँड लेट अस डिझाईन द लॉ. जॉईंट सेक्रेटरी एक येऊन बसला. जॉईंट सेक्रेटरी म्हणजे काय करायचंय, शिर्डी बनवायचं आहे ना आपल्याकडे पंढरपूर तयार. कॉम्प्युटरचं बटन दाबलं आणि पंढरपूर काढला, म्हणजे रिप्लेस पंढरपूर बाय शिर्डी. So what is the need of the Shirdi? What is the need of the Pandharpur? What are the differences in the two institutions? It is always to be seen when you are making a law. There is a one line, friends, as a law student you should understand. Before every law it starts, there is a two-line aim and object of that particular law. This law is made for this purpose. That one line is always a guiding line for making an interpretation of whatever sections are there and whatever rules are framed in that particular rule, that particular act. That one line interpretation will be said to be an intention of the legislature. You have heard this word, intention of the legislature. For what intentions this particular law has been made. And therefore, understanding the making process of the law by the law student when they are participating in this type of discussion is also important. Secondly, friends, as a law executors, suppose a case come to you that this particular publication on a OTT platform has made a defamation. The aspects will have to be considered. And for that purpose, a simple law before you, which you should learn, is a law of defamation. What is the 499 provisions of IPC? What are the 599 provisions of an IPC? Decency, morality, on which section 292 to 294 of the Indian Penal Codes are there. If it is relating something to the government, if suppose the government and the privacy of the government, sovereignty, some security of the nation, if such types of publications are there, you can go to the Information and Technology Act and you will find that there is a section 69A which gives a lot of powers to the central government. Any matter can be deleted. It can be prohibited. There can be a jammer. You can go to any place of any national importance. You will find that the entire approach, entire access to your mobile and all electronic instruments are not free. There is a jammers. So these all authorities are there even today. These authorities are there. Then what is required? So requirement is that now, as a consumer, when a particular publication is going to be accessed, linked by the citizen of this country, by making some payment, what should be the control on that need of the consumer? This is the core line of making of the law on these particular aspects of restricting OTT platforms. Is any regulation required? Yes, I am of the opinion that certain regulation is required. Why it is required? Because certain publications through these OTT platforms are reaching in your houses, which are against your own social and public, you can say, culture, your own whole culture, your own Indian culture. And moreover, that is not decent, moral. That is one side. To a certain extent, these types of restrictions are required. What is not required? Criticism. Criticism is again another instrument in a democracy which should keep even a man on a great position with an authority in streamline. The role of newspaper, the role of television, the role of radio, and therefore fourth pillar of the constitution with law making, law execution and bureaucracy is the media. Media is the fourth pillar. They are supposed to criticize these three pillars if they are doing wrong. So that aspect of the criticism should not be killed. Recently, you must have seen that case of Showmaker. The younger generation know. And in that show, a certain, on a lighter aspect, certain comments were made. And in that comment, ultimately the government banned that particular show because there was a criticism on the government. John Oliver's show on Hotstar. This was banned recently. Then there is a Hassan Minaji show, which was regarding the election held in 2019, Lok Sabha election, criticizing the rulers. It was banned. The question is that the aim and object, which I told, of making of the law should not be that it should kill the criticism. Because the criticism is the basis for the democracy, for having a healthy democracy. And for that particular purpose, the balance between these two things, that the morality, the decency, the culture should be tried to be protected by certain regulations. On the other hand, there should not be such a provisions of the law whereby ultimately the criticism will be killed. This is a time where democracy, protecting the democracy is against a great challenge before the persons who are in a field of law. They may be a lawyer, they may be a judges, they may be any other journalist, they may be other thinkers. Before them, this particular aspect is very important. And that particular aspect has been recently considered when this IT Intermediary Guidelines and Digital Media Ethics Code Rule 2021 has been brought into force by the government, whereby now this particular reasonable restriction under Article 19(2) has been brought into picture. And further now there is also need to have a substantial law, because law in hand today, as on today, is an information and technology law. Also there are certain rules under the information technology rules also, which gives you certain power or certain provisions which I have just quoted about the section 69A or even section 292 to 294 of the IPC. Whether there should be such a censorship or not, there is a survey conducted by the government, particularly the branch of the government, if you ask me, that is the Ministry of Electronics and Information Technology, Department of the Government of India. They conducted certain survey whether there should be certain restrictions on this aspect. 57% of the people told that yes, certain restrictions are required. And this particular portion should be, this restriction should be related to the public health, public morality, and not in respect of an individual controls or killing the criticism. That is the sense given by the 57% of the people. Here also one thing is important. In this 47% of the people who said that there is a requirement of a censorship, reasonably restricting these OTP platforms, out of that, in this 57%, majority of the persons are above 40 years of the age. And the younger generation, below, in between 18 to 40, they feel that they near about 43% out of 43%, near about 70% are the younger generations coming from this age group, 18 to 40. This says that no such types of restrictions which is not required. If we see the international scenario, friends, what is an international scenario perspective? In countries like Singapore, UK, there are regulatory bodies and they are keeping a regular check on these OTT platforms. If you see some of the countries like Turkey, they have started giving license, and out of license whatever the permissions will be there, for 10 years a license will be given, and on the basis of that, by observing the norms of a license, you can publish, you can exercise your OTT platforms. In countries like Indonesia, certain part of Turkey, Saudi Arabia, they had strictly regulated this. They have prohibited, they have banned. In Saudi or in Gulf countries, you will not find that all sorts of OTT platforms are open for all. And therefore, this particular aspects of controlling OTT platform depends upon the cultural and social political aspects of every country. There is no universal policy as such on this particular aspect. Even there is a scrutiny under the United Kingdom and USA, there is a scrutiny. So on the basis of this, what should be our conclusion? Because I have completed my time and already now your second session we are overlapping by 30 minutes. The government should carefully look into this. The 1921 rules are subjected to the challenge before the Supreme Court. Number of petitions are filed before the Supreme Court. And now, as told by Honorable Nimbalkar sir, three-tier regulatory suggestions are before the government, which will be mostly coming into the picture. One is to create redressal grievance committee internally by that particular OTT platform. If something is objectable, that should be addressed to that OTT platform. First tier. Second, a tier is that a self-regulatory body should be created. And in India, near about 15 OTT platforms have signed an MOU that yes, we will create a self-regulatory body. And such type of a representation has been given before the Supreme Court in the pending petitions. Third is that this second aspect, this statutory body will be headed by the retired Supreme Court judge or a High Court judge, and under that, just like a press council, tribunal is there, press council tribunal is there. Similarly, on the basis of that, this self-regulatory body will be there. And third tier will be that interministerial committee. It will be controlled by the government. They will be doing an adjudication as a tribunal. If any complaints are there, or probably they will make a mechanism that in a second committee, self-controlling regulating body, if any objections are to be raised, probably that will go to the interministerial committee, which will be headed by the superior officers and maybe some retired Supreme Court judges. And accordingly, this particular regulatory aspect is before the country at presently. Supreme Court is considering. Let us give thought to that entire subject. I will say that after the conclusion of this seminar, the institution should make a paper. It should be addressed to the Bar Council of Maharashtra, Bar Council of also India. We are the representative of 2 lakhs lawyers, madam. Our representation will be more powerful for that. We'll consider it. It's not that your all suggestions will be accepted by the council or their members. We will discuss it in a full house. And after making a discussion in a full house, whatever regulatory methods we found adequate, we will suggest to the government of Maharashtra, we will suggest to the central government, we will represent before the parliamentary committee, and we will try that this particular aspects of making of law should take some good shape. While making this shape, the aspects of democracy should not be going back. We have to take the democracy ahead. Friends, we are in a progressive democracy. Initially, Indira Gandhi was getting 450 seats. Then there was an emergency. Then there was a Janata government. Then there was a splits government. Again, there is a government of the Bharatiya Janata Paksha with substantial number of majority. The people says that what is this? This fragmented democracy is weakening to the nation. Maybe on an administrative level that may be correct. But our democracy is not going back, friends. We are in a developing democracy. In a legal history, the basic country who has developed the concept of the democracy is England. And they are having a heritage of 800 years of a democracy, making of the law. They don't have a written constitution. You know that, no? England do not have a written constitution. They work on the precedents. For 800 years they are working. You see their history. You see their development of the democracy. You will find that 150 years there was the same chaos situation. And on that, whenever the learned persons from the political science express their views, there is a thesis in a political science. And this is that this is a fragment democracy. Don't worry, it's good. Hanging parliament is a mature state of democracy, is a political thesis. When there is a hanging parliament, it is not going back of the democracy. People are thinking, people are giving votes to the different parties. There are different thoughts, there are different culture, there are different ideologies. People are talking about that ideology. They are voting for that. They are coming into elections. And this process of entire democratic development is good for the further development of the democracy. In this process, important thing is that we should have a habit to think logically with a jurisprudence in our mind, and by understanding what is the requirement of the current situation, what is the requirement of the society, and what requirement if fulfilled with the law will be better for improving the democratic setup of the country. Let us be a part of that. I congratulate the college, I congratulate the institution, and I welcome their suggestions on this topic, which we will try to take up to the Parliament. Thank you very much.
Thank you so much, Jai Bhave sir, for sharing so many thoughts. I really thank you for sharing all the legal aspects strongly. And with this, we aimed our inaugural session. I really wanted to thank one more time Jai Bhave sir, Advocate Nimbalkar sir, for gracing this occasion with their presence. Thank you so much, sir. I think sir really deserves a big round of applause for his valuable thoughts. He has really made this session very interesting. So thank you one more time, sir. Thank you. Okay, so with this we move ahead with our first session. We have with us Advocate Rajendra Anbhule sir. I would like to invite Advocate Rajendra Anbhule sir on the stage, please. Welcome, sir. Yes, so we have Advocate Rajendra Anbhule sir with us. So welcome. And we are now going to start with the felicitation, and to do so I request our principal ma'am to kindly felicitate Advocate Rajendra Anbhule sir. With the big hands, we'll welcome sir, and it's a real honor for all of us. He's the keynote speaker for today's session. A nice bouquet and shawl. Thank you, sir. Kindly be seated. I would like to invite Assistant Professor Seema Patil ma'am to introduce Advocate Rajendra Anbhule sir. Over to you, ma'am.
Thank you, Nayan. A very good afternoon to all dignitaries on dais, our honorable resource persons who are present online, all participants, and my dear student. I, Assistant Professor Seema Patil, is privileged to introduce our respected resource person, Advocate Dr. Rajendra Anbhule sir. Sir has pursued MA in Pol Science and has been a gold medalist in Pune University for securing first rank. Sir also got Best Student Award in ILS Law College in the year 2000. Sir has completed his doctorate in law and also diploma in labor law and labor welfare. To add on this, Sir is a Supreme Court advocate and record. Presently, Sir is a Chief Coordinator of Bar Council of Maharashtra and Goa, and Sir also authored various books on different law subjects. Sir has been in charge principal of Marathwada Mitra Mandal Shankarrao Chauhan Law College, Pune. Along with his academic experience, Sir has also member of a board of studies in Faculty of Law at Bharati Vidyapith, Pune. Sir also worked as a member of the Academic Council of Maharashtra National Law University, Mumbai, and Honorary Director, Center of Advanced Legal Studies, Training and Research of Member of Academic Council of Maharashtra National Law University, Mumbai. Sir also practiced in Bombay High Court, Supreme Court of India in the area of Constitution of Law, Civil Laws, Criminal Laws, Personal Laws, Services and Educational Law. There is a very important aspect which I want to introduce or I want to mention here, that Sir also filed public interest litigation in Supreme Court for ultimate rehabilitation of orphans, in which Maharashtra government filed an affidavit, in pursuance of which now 1% reservation is given to orphans in Maharashtra. Another important aspect which I want to mention here is that Sir also filed PIL in Bombay High Court, as a result of which full-time protection officers are appointed in Maharashtra under the Protection of a Woman from Domestic Violence Act 2005. Sir also acted as a resource person for Bar Council of Maharashtra and Goa, Maharashtra State Commission for Women, Women and Children Development Department, Maharashtra, Yashwantrao Chauhan Development Academy, Pune, Police Research Center, Pune, Police Training School, Khandala, and State Intelligence Bureau, Pune, etc. So, we indeed very honored and privileged to have you, sir, as a resource person to address our audience. Now, sir, I would like to invite you to share your words of wisdom with our audience. Over to you, sir. Thank you very much.
So before you address, we would just like to take 30-40 seconds break, because we are just going to change the arrangement and we are going to listen to your speech, sir. So friends, we are going to start with our first session of the conference, and this is going to be a very interesting one, because we have with us the very great personality, Advocate Rajendra Anbule sir, who is going to download so many aspects, legal aspects of OTT platform. Sir, over to you. We are really honored to have you and eager to listen to your speech, sir. Thank you so much.
Very good afternoon to everybody.
Good afternoon, sir.
Respected dais, Honorable Honor Madam, Principal of Maharashtra Vidyapith Law College, and all my dear participants. The title of the one-day international conference is Tighter Legal Regime for Media and OTT Platforms. While discussing this particular title, the topic which has been assigned to me is in relation to infringement or violation of copyright vis-a-vis OTP video piracy. So in present session, I am am going to speak in relation to this new platform and how their rights are to be protected. My lecture may not be confined only with an attempt to protect the rights of this new regime or OTT platform, but at the same time I am going to discuss the constitutional dimensions as well as statutory responses in India along with judicial discourse in the area of this particular new platform or system. As we are the students of constitutional law, it's a fact that media freedom is one of the facets of freedom of expression which has been enshrined under Article 19(1)(a) of the Constitution. Certainly, in the passage of time, some restrictions were put by legislature on these particular freedoms, and with a view to answer the arbitrariness of that particular executive actions or legislative actions, even judiciary had stepped in, wherein some sort of principles have been laid down by Apex Court in relation to interpretation of this particular right. It may be a reasonableness of restrictions which may be there in relation to Article 19(1)(a). But at the very outset, what I want to state is that media freedom is one of the important facets of freedom of expression under Article 19(1)(a) of the Constitution. I may say that this is one of the important development after the commencement of the Constitution, wherein within the purview of freedom of speech and expression, this particular new area has been covered by the Apex Court. There are several judgments, category of judgments passed by Supreme Court of India as well as High Courts, wherein court has tried to protect media freedom within the ambit of freedom of speech and expression. Despite that, we may say that due to technological progress, certain new developments have took place, because of which time has come to interpret this particular freedom in new form. Parliament has enacted so many laws with a view to regulate and supervise this particular freedom within the ambit of Article 19(1)(a). At the same time, even judiciary in India is also proactive, and so many new decisions are there which are given regulating freedom of speech and expression from both the sides by balancing that particular right. But as we know that society changes faster than law. Society always changes faster than law. Firstly, society change, and then law has to respond to the change which is there in the society. So sometimes it may happen that the society has changed, but the law is not adequate. Law is not responding properly to the need of the society. So, in relation to this particular topic which has been assigned to me, that is infringement of copyright and over-the-top video piracy, that is OTP piracy. Very importantly, what I want to suggest is that though existing laws are there, that may be there in the form of the Copyright Act 1957, or it may be even in the form of Information and Technology Act 200, wherein 2000, wherein some sort of provisions are there to regulate this particular, we may say, new platform. But despite that, very importantly, the present need is to modernize the law and even to initiate some progressive steps so that this particular area will be properly regulated, not for only the betterment of the society, but even for the betterment of law also. You must be aware that in 2019, Kerala High Court had given one judgment that in the case of Fahima Shirin case, wherein Kerala High Court in 2019 held that right to internet is a fundamental right under Article 21 of the Constitution of India. So you are having right to access the internet, you are having right to enjoy that particular aspect in daily life. Now, when right to internet has been held by Apex Court as a part of fundamental right under Article 21 of the Constitution of India, before discussing the further aspects in relation to this particular concept, let me clarify one thing. Right from 1950 till 1978, the Apex Court of India was highly influenced by analytical legal positivism of Austin. That law is a command of sovereign addressed to the people, which is secured by physical force of the state. And if you read some judgments of even Justice Gajendra Gadkar, he has categorically stated in his judgments that we are here as a servant of the legislature. We cannot make something new. We are here only to interpret the law. Even Gopalan versus State of Madras, which was decided by Supreme Court in 1950, was nothing but, we may say, the pronouncement of the principle which was laid down by analytical legal positivism of Austin. Except Justice Fazal Ali, who was dissenting in that particular case. But in 1978, A.K. Gopalan versus State of Madras was overruled by Apex Court, and a new concept was developed under Article 21 of the Constitution of India, that is inclusivity of fundamental rights. This doctrine of inclusivity of fundamental rights says that there is close nexus, close connection, close relationship between Article 21, Article 19 and even Article 14 of the Constitution. When Article 21 is violated, Article 19 is also violated, and at the same time Article 14 is also violated because discrimination is there. So when Fahima Shirin case of Kerala High Court in 2019 says that right to internet is a fundamental right under Article 21 of the Constitution, it speaks volume of the fact that even Article 19 and Article 14 are also part of that, because all these fundamental rights forms part of one single scheme. So very importantly, when right to internet is denied, that cannot be only a violation of Article 21, but it can be even a violation of Article 19 as far as freedom of speech and expression is concerned. It is also a violation of Article 14 for the reason that the action is arbitrary one, and that has been applied in case of that particular person. So, when this particular judgment came in 2019, that is Fahima Shirin case of Kerala High Court, Kerala High Court said that right to internet is a fundamental right under Article 21. Now, in India, there are several platforms which are available to the customers like us or to the viewers, so far as media is concerned or viewing of that particular media is concerned. As I said earlier, that there is a technological progress in India. This has led to commitment of some sort of illegalities by the perpetrators. So, technology development is there, but at the same time, there is increase in violation of right to, we may say, copyright, or at the same time, there is also video piracy in relation to UTT platforms. So, today, in my lecture, in my submission, I am going to make attempt what copyright law is there in India, how OTT has come to India, how rules and regulations are there, whether they are properly responding, what the court is having view about this particular new platform, and at the same time, what suggestions are required, what solutions are required to make this particular OTT platform more effective. Now coming to first aspect of today's discussion in relation to copyright law in India. You all must be aware that the Copyright Act 1957 is there in India, which discusses about protection of rights in relation to that person who is a creator of any particular thing. Now, even though Copyright Act is there in India, despite that, I may say that this particular act is not effective in present form to answer the online video piracy which is committed by those perpetrators who are not even identifiable. And that is the most important concern for today's discussion. If you see section 14 of this particular act, the Copyright Act 1957, then it discusses about the meaning of copyright. And very importantly, copyright is confined to reproduction and distribution of any particular thing or any particular right which belongs to that creator. So two important words are there in section 14 of the act, that is, something is already produced and that particular person who is a creator has a right to reproduce that as well as even right to distribute that. So reproduction of a thing which is created by a person and distribution of that particular thing which is created by a person is very important part of copyright as far as section 14 is concerned. Now if you go to section 13, before section 14 of the act, then it has been mentioned there that in what cases the copyright subsists as per the mandate of the act. And there are three important things which are mentioned. The first is copyright can subsist in relation to literary work, in relation to dramatic work, in relation to musical, and in relation to artistic work. That is the first aspect. Second aspect is copyright can subsist in relation to cinematograph, films, and third is the sound recording. Now, so far as second and third aspect is concerned, the duration of copyright as per section 26 and 27 of the Act is for the period of 60 years. For 60 years, that person is entitled to enjoy that particular right under the provision of the Act. And very importantly, there is a judgment of Apex Court wherein court has clarified that the copyright right which is given to the creator is a right which is covered under section 300A of the Indian Constitution. So that right to property is available to that particular creator which cannot be taken away except as provided by the law is a provision in section article 300A of the Constitution of India. And at the same time, it has been clarified by the Apex Court that the right which is available to the copyright holder is not the same like a licensee. If license is given by him to any other person, then there may be some sort of restrictions and limitations which can be imposed by him. So after this particular copyright law which is of 1957, another important concept is there, that is what is OTT revolution in India. Now as my topic is infringement of copyright and over-the-top video piracy in India, it is very important to discuss second important aspect after Copyright Act 1957, that what is OTT platform, what is OTT revolution in India. In simple words, if any content is distributed via internet, then it is treated as OTT platform. OTT means over the top. Over the top means what? Over the top means that the content is not distributed through any traditional method like radio, or we may say like TV, or like any satellite distributor. This is new form. Via internet, something is distributed to you, the content is given to you, and you can receive that particular content, you can view that particular content, and you can even use that particular content as per your requirement. So OTT, which is over the top platform, is directly offered to the viewers by internet. So very importantly, so far as OTT revolution in India is concerned, we may go to 2008 when Big Flix was there, which was introduced by Reliance Group. After that, IPL matches were started in India, and that matches were also viewed by us on OTT platform only. But it was only in last 2-3 years during even pandemic, we may say COVID-19, that OTT platform assume very, we may say, large importance in Indian, we may say, media services as well as distributorship. And more popularly, I may say that the Netflix is one of the important aspect or important part of this particular new platform. After Netflix, even Amazon Prime Video is also part of OTT, even Hotstar or Z5. These are the OTT platforms which are available in India. Now, the issue is that what new is there in this particular OTT? The new is this, that if something is given to you directly via internet, and if you are going to access that, if you are going to view that, then it is we may say different from traditional forms which were available in India. So on this particular count, OTT can be treated as different from the traditional method of viewing something which was available in India. Now there are certain advantages of this particular OTT platform, and the first important advantage is that OTT platform is very easy to access. Access is very easy. You can access Amazon, Netflix, Hotstar, Z5 even on your mobile, even on your iPad, even on your desktop, or even on your smart TV. Such kind of forums are available there. So access is also very easy now as far as this new method is concerned. And at the same time, this OTT platform is very cost effective. Cost effective in the sense that traditionally you were taking package of suppose cable TV, and in that particular cable TV there were packages of 50 channels. Today you can say I don't want 50 channels. If you subscribe to suppose Netflix, you can decide what you want. So as per your desire, as per your choice, you can select the content, you can pay for that and you can view it. So it is very easy now, it is cost effective. Cost can be reduced now. So as per the requirement of the viewer, any particular content can be purchased by him, and via internet he can access that and he can use that particular content as per his requirement. And the third important even benefit is also there, that is this OTT platform has created, we may say, opportunity to new talents. So gone were the days where this particular right was exercised by few people, but today new opportunities are created in the area of media also, and because of that there is we may say chance to those who want to exercise, want to we may say develop their talent. And last important aspect is there so far as use is concerned, that because of OTT platform there is a broader outreach. Broader outreach in the sense that these OTT platforms can be viewed internationally also. So that is also a very important aspect in relation to this particular OTT platform, which is a new regime in India. But at the same time, the question is often asked that in relation to Copyright Act or violation of copyright, whether this particular new regime which is there is properly regulated by the state or not. Whether the present laws are sufficient to supervise the menace of video privacy. And very importantly, if we scrutinize the laws which are there in India, existing laws, then again we have to go back to Copyright Act and to some sort the Information and Technology Act of 2000. These are the only two legislations which are discussing about OTT video piracy in relation to copyright, and some important provisions are there in this particular acts which discusses about the same. I will confine only 2-3 minutes to discuss that particular statutory academic discussion, and then I will come to some practical aspects. If you see section 2M of the Copyright Act 1957, then it discusses about infringing of copyright. So what is copyright you can discuss in section 14 of the act, and what is included in that particular copyright is in section 13 of the act. But in section 2M of the act, infringing copyright has been discussed, wherein it has been discussed that if there is unauthorized reproduction and distribution of any particular content, then it amounts to infringing of the copyright. So the word unauthorized is very important in relation to infringing of the copyright as per section 2M of the Act. And if you go to section 51 of the Act, you can read section 51 along with section 2M of the Act, wherein if unauthorized reproduction and distribution of any particular content of copyright is there, then it may attract civil as well as criminal liability, has been mentioned by section 51. Now, we cannot say that no attempt has been made by Parliament of India to regulate or to supervise this particular menace of the video piracy in relation to OTT platform. Certain amendments are definitely there in Copyright Act, but the issue is whether these amendments are sufficient to tackle the problem presently is the issue. But Copyright Act was also amended and section 65A and B were introduced in the Copyright Act of 1957, wherein infringing the digital environment has been also discussed in relation to OTT platforms. And after that, section 63 of the Act discusses about offences wherein punishment is provided and there is a criminal liability on the person if there is breach of any particular copyright. If you go to Information and Technology Act of 2000, then section 43 and section 66 are very important, which discusses about online distribution of any particular content punishable if it is unauthorized. So there is close nexus between section 4366 and Copyright Act of 1957, because if unauthorized use of any particular content is there, if there is a reproduction or distribution which is unauthorized one, then section 43 and 66 of the Act of 2000 also make it punishable offense. And more importantly, section 79 of the Act of 2000 is very, very important, because it discusses about liability of intermediary. Intermediary in the sense that if you are using any particular, we may say, platform, and if you are misusing that particular right of any particular, we may say, author, then it is the duty of that particular intermediary to take action against you and also to inform the appropriate authorities. So these particular rules and regulations are there in relation to the copyright as well as video piracy. And I may say that in case of Telegram also, if you are misusing that particular Telegram by committing any kind of piracy of any particular content, then as an intermediary, it is the duty of the Telegram to inform the higher authorities or legal law authorities to about the commitment of that particular illegality. That has been mentioned by section 69 of the Act of 2000. Now coming to most important part of today's discussion, that how copyright infringement can be there in relation to OTT platform. Now sometimes it may happen, if any content is there on any OTT platform, suppose like Netflix or Amazon Prime Video or Hotstar or Z5, whatever it may be, or any other particular platform, then a person may commit piracy in relation to that particular videos. So that video may be downloaded by Telegram boot. It may be downloaded even on Google Drive also, or on any other particular, we may say, website. And by downloading that, we may say, pirated versions can be created. Now, after creating that particular pirated versions, it can be distributed to any other people who can also distribute to another, and there will be link of so many people who may misuse that particular contents. Now, that contents may be available free, but so far as this OTT platform owner is concerned, he is going to he will go to the hardships financially. There may be financial loss to him because his contents are pirated, his contents are stolen, and they are distributed by the viewers with so many people. And very serious problem in relation to pirated version is that you cannot trace the offender. There are so many people who are involved in that. It's a question of ultimately jurisdiction, how to identify that particular person and how to take action against him. So, very importantly, intellectual property of OTT is used illegally so far as OTT breach is concerned or piracy is concerned, and as I said earlier that it is very difficult to identify the person who are the viewers. Now the question is in relation to today's discussion that if this is so, if you identify the person, you can give notice to him. So legal notice can be issued, it may be answered. If not, if there is any financial loss to you, then as a owner of that particular platform, you can take action. But the question is, if the offender is not traceable, if the offender is not identified, if the offender is unknown, then how action is to be taken? So, very importantly, we have to discuss the laws which are created in United Kingdom in the form of John Doe order. Now what is John Doe order? John Doe order, John-DOE order, is a form of order which was invented by Queen's Bench of United Kingdom, and it is an equitable form of remedy. This John Doe order can be issued against that person who is unknown. Now you don't know who has committed that particular piracy, but it is there. And if the person who is author of that particular, we may say, OTT platform come to know that there is a violation of his rights, then he may definitely approach to the court and he may request for John Doe order. Now what is the John Doe order? If order is issued by the court, that order is in the form of injunction, manai hukum. And what kind of injunction is there? That person who is unknown can be directed. By issuing the order, court can direct that particular person from using that particular content. So, the question is whether injunction against unknown person is applicable in India or not, which is applicable in United Kingdom and other states. So, for the first time in 2000, we may say 3, the Delhi High Court had given one judgment in Taj Television versus Rajan case. And in Taj Television versus Rajan case, John Doe order was passed by Delhi High Court. Now, as I said earlier, if the person is identified who has committed any particular crime, who has committed any particular illegality, notice can be issued to him. After issuing the notice, you can even initiate action in the court of law for damages or compensation. But if the person is unknown, then also remedy is available, and Delhi High Court was convinced that yes, John Doe order can be issued to that person who is unknown, and by issuing that particular notice, even we can issue the injunction. But for that purpose, 3 important rules are to be there. Number 1, very importantly, the person who is a plaintiff, the person who is a petitioner, has to convince the court that his right is breached by some unknown person. Number 2, he has to convince the court that he has a prima facie case. प्रथम दर्शनी त्याच्याकडे चांगली केस आहे. And thirdly, he has to convince the court if no remedy is granted, then irreparable loss will be caused to him. जर त्याला मदत केली गेली नाही, न्यायालयाने जर आदेश दिला नाही, तर त्याचं खूप मोठं आर्थिक नुकसान होऊ शकतं. He has to convince the court, and if this happens, if these 3 requirements are satisfied, then court can pass John Doe order by which unknown person can even be directed by the court by issuing the injunction. So, right is breached by any unknown person. A person who is petitioner is having prima facie case, and third important aspect is that if no relief is granted, then irreparable loss will be caused to that particular person. So, in India, so far as infringement of copyright is concerned, vis-a-vis, we may say, video piracy on OTT, at present, the Copyright Act 1957 is there, which is also amended for some time, wherein attempt has been made to bring some piracies within the ambit of the law. At the same time, even Information Technology Act of 2000 has also made some attempts. If I am asked that whether this particular development is satisfactory or not, I will suggest that the present laws, the present regime which is there today in India is not effective to tackle the issue relating to OTT video piracy. Something new shall be there, and as I said earlier, what new shall be there is that we have to modernize the law. After modernizing the law, we have to take some progressive steps so that we can properly tackle with this particular menace of video piracy in OTT. And at the same time, very effective online regulation regime is required in relation to this particular technique. And as I said earlier, that there is an issue of jurisdiction. Suppose if any illegality is committed in Nepal or Sri Lanka, then it is very difficult to take action. So, as the issue is in relation to jurisdiction, as so many perpetrators or culprits are involved in relation to this violation of piracy, I think, or I have a suggestion that our Indian laws shall be in consonance with the international laws and treaties which are there. Our state law and our state law shall be similar to the laws which are there in international arena. And if this happens, if there is unity in Indian law and international law, then only this new particular regime of OTT platform can be implemented effectively, and that will be the best practice which can be used in relation to this particular new technique. I am very much thankful to TMV Maharashtra Vidyapeeth New Law College and Principal Madam for giving me an opportunity to discuss this particular title today. Thank you very much.
Thank you so much, sir, for letting us know so many concepts, case studies, and close nexus about copyright law, video privacy, and so many things. So we had to honor you with this special moment to hear. So I request ma'am to kindly honor sir with this special memento. Thank you so much. Yes, moving ahead, I would like to invite Assistant Professor Akshay Kabra sir to kindly introduce our next speaker, Mr. Satya Prakash. Welcome, sir. Over to you. This session is going to be an online session, and to introduce our speaker, Mr. Satya Prakash, I am inviting Assistant Professor Akshay Kabra sir on the stage, please. We are just going to take 2 minutes break over here because this is going to be an online session and we are doing some technical arrangements over here. And if you have any questions regarding this online session, you can write it down, and please you can give the questions to our volunteers which are there at the back side.
देशमुख साहेब हो देशमुख साहेब कोणाचे पान संभाळची आहे ना हां ते तुमच्याकडे द्या म्हणले पान संभाळ चिटिंग करत जातं कॉलेज झालं 1 वाजेपर्यंत ते आता हे झालं ना ते स्टुडंट चालू होतील त्यांच्या स्टुडंट्सचे लेक्चर होणार लेक्चरना म्हणजे क्वेश्चन तेच ना नाही क्वेश्चन आन्सर नाही पेपर 500 रुपये नव्हते का भरायचे काही जणांनी खायचं घ्यायचं का नाही हो साहेब गेले ना हां मुठकोट नव्हतं का उद्या मॅडमनी धरलं
My colleagues, participants and my dear students, I, Assistant Professor Akshay Kabra, take immense pleasure to introduce our guest for this session, Mr. Satya Prakash sir. Being in the field of journalism, sir has completed his Masters of Arts in Mass Communication from Guru Jambeshwar University of Science and Technology, Hisar, Haryana, and has done his Bachelor's of Law from Delhi University. Sir has completed his BA Honours in History as well as an appreciation course in Parliamentary Process and Procedure along with a postgraduate diploma in journalism. He started his career as a sub-editor at the Press Trust of India, from wherein he became a reporter and a legal correspondent, and has also worked as a legal editor at Hindustan Times. He has been a research associate at the Center for Study of Developing Societies, Department of Science and Technology, Government of India, New Delhi, and Council for Advancement of People's Actions and Rural Technology, New Delhi, wherein his most recognized work was a comparative study of custodial death. He is currently associated as a legal editor with the Tribune and also writes a weekly column, Obiter Dicta. In his professional capacity, Sir has exposed scams involving politicians and bureaucrats such as Hawala scam, Bofors payoff case, urea scam are a few to name. With his academic soundness and his passion for teaching, Sir has been associated as a visiting faculty in various institutions such as IIMC, Jamia Millia Islamia, Symbiosis Law School Noida, Xavier Institute of Management Bhubaneswar, Delhi University, and Times School of Journalism. He has also delivered lectures in renowned institutions like UGC Human Resource Development Center JNU, High Court of Manipur at Imphal, Institute of Criminology and Forensic Science, New Delhi, Symbiosis Institute of Media and Communication, Pune, Sarojini Naidu Center for Women's Study, Jamia Millia Islamia, New Delhi, and Institute of Management Studies, Noida. With his vast knowledge and hands-on experience, Sir is a mentor and a member of various institutes like UNESCO and Center for Media Studies, WHO Road Safety Media Fellowship, and many more. Sir has not only used his skills in academics, but has also made the most of it by interviewing eminent personalities such as British Justice Minister Lord William Beck, Pakistan's Law Minister Muhammad Wasi Zafar, Afghan Foreign Minister Dr. Abdullah, Chief Justice of India V.N. Khare, and Sri Lankan Prime Minister Mahindra Rajpaksha. Sir's excellence and experience have been recognized, and he has been awarded with Ladli Media and Advertising Award for Gender Sensitivity, National Bar Award, as well as Dr. Shankar Dayal Singh Trophy by the then Chief Justice of India, B.N. Kirpal. It is an honor to have you with us today, sir. We welcome you, sir. Now, I request sir to kindly address the audience. Thank you.
Very good afternoon to all of you. And I'm sorry I'm starting quite late. And a couple of things, like this is the session just before the lunch. So all of you must be hungry. But notwithstanding that, this topic as has been discussed since morning, there are various aspects of this topic. Just certain aspects relating to copyright was discussed just before this session. And then before that, the larger issue of OTT platforms and the legal regime and how it's being regulated in India and abroad, that was discussed. I'll try to address some of the aspects which had not been dealt with. And because this largely relates to media law. And it's a very complex issue in the sense there are certain issues relating to constitution, certain issues relating to a state and its safety and security. There are issues relating to, media theory. There are certain issues relating to right to property, law and society, maybe certain rights of the consumers. And immediate issue, why we are discussing it, the OTT platforms, and relating to that, last year there was some regulation which was brought in by the government, and that is how we are discussing it. See, As we progress as a society, not just we in India, but across the globe, when I say we, I'm talking about the entire humanity. These societies are becoming much more technology-based society. We cannot do without technology. But when we are moving to adopt technology, it is becoming much more complex society, because with technology, we are supposed to upgrade our laws as well. Because in any case, with technological upgradation, the old system of regulation that we had, or in many cases we did not have any, that needs to be upgraded, augmented, and accordingly, if we don't do that, we increasingly find a gap between technology and law, leaving it, the gap sometimes it's so big that there are so many complications, litigation, and you will find that because of this gap, we are facing problems on the face of regulation, on the face of law, on the front of security issues. So this gap between law and technology is my first formulation, and that needs to be addressed. Unfortunately, what has happened in India is the executive and the legislature they have been found wanting, and rather I'll say they have been rather caught napping. And because of their inaction or inability to respond to the changing scenario in time, this problem is getting bigger and bigger, and this is creating problem for society, creating problem for the state system, creating problems for all the regulatory bodies, creating problems for the entire legal system. So this is one. Second is about this entire issue relates to media and media's role and certain aspects of media theory. Before I get into this gap, the basic role of media. The role of media is to inform, educate, entertain, to set the agenda for debate in the society, to act as watchdog for democracy, and in the process, media is acting as a sort of interface between the society and the state system. If there is something wrong with the society, we show it to the state, and then the state takes correctional measures. If there is something wrong with the state system, we show it, and the society, because we are a democratic society, we have a system of checks and balances, periodic checks and balances through elections, and daily checks and balances through the system of our assemblies and parliament, where members can ask questions and hold the government to account. And this is how it works. But this entire system of checks and balances and the media's role, there is a framework. In previous sessions, some of the speakers have tried to talk about the framework. But one particular aspect which has added some newer dimension to the entire debate is the fact that now we have right to privacy as a fundamental right, courtesy Puttaswamy verdict of the Supreme Court in 2017. We have a right to have access to internet as a fundamental right now, courtesy Anuradha Vaseen's verdict in 2020. So when I say right to have access to internet, it is not just a right to have access to internet for exercising free speech, but also for conducting business, trade, occupation, profession under Article 19(1)(g). So this aspect of media is getting much more complicated. But apart from this, we have a state, we have society, we have individual rights, we have the market forces which want to sell their products. We have consumers, they also have rights. So this is, and in all this, the state is supposed to give us a robust regulatory mechanism addressing the concerns of all the stakeholders. Unfortunately, the state has been, as I told you some time back, the state, particularly the executive and the legislature, they have been caught napping. And there has been a policy paralysis. And because of this and this gap, the entire scene is very, very complicated. And then we are supposed to discuss this and then throw up some suggestions. So far as OTT is concerned, before I get into OTT and then the regulatory aspects, and as I mentioned to you, the gap between technology and law, just briefly, the aspect of media theory, which is very important to understand this entire controversy, which is the role of media as we see, and as I have just mentioned, the 5 or 6 roles, including setting the agenda for debate and acting as a watchdog or acting as sort of interface between the society and the state system. What is important is media, its role in different societies, it performs it in a different manner because of the state structure of the state. And that was in 1950s. There were 3 American scholars, Fred Siebert and Theodore Peterson, and I suppose Wilmer Strom, I'm forgetting the third name. They had given this media theory, and there are largely 4 theories. First is known as authoritarian theory. The second, the communist or Soviet theory. Third is libertarian theory, and fourth is known as social responsibility theory. These theories are very important to understand how media performs its role in a particular society which is functioning under a particular type of state structure. And this is very important. So far as authoritarian theory is concerned, media is a tool in the hands of the authoritarian state. And you and I, as individuals, or even collectively as a society, we don't have the amount of media freedoms which currently we enjoy. So there is hardly any media freedom because media is completely controlled by the state, rather authoritarian state. And because it's controlled by the state, there is no other individual or any other entity which can enter this entirely. So there is complete control of the state over the media, to the exclusion of rest all. And because of this, what happens is that media becomes a tool in the hands of the state to perpetuate a status quo. You cannot show anything which can remotely also disturb the status quo, that is somehow indicate that this ruler or authoritarian can be pushed aside. No. The second is known as communist theory or the Soviet theory. This is followed in most of the communist countries, including China or Vietnam. I have been to Vietnam. I was surprised to see that. And I have received at least 2-3 Chinese delegations when I was the Hindustan Times legal editor. And they were all stunned, the Chinese guys, because when they were sitting with us in an edit meet, somebody picked up Times of India and they asked, is it the government newspaper? And we said no. Then Hindustan Times and then Express. By the time the fellow picked up Indian Express, our editor told them, look, the government runs government. We don't run, the government doesn't run any newspapers. So they were, so they asked, there is no government newspaper. They were told no. There is no need for the government to have to own newspapers. So in the communist system of state structure, there is again complete exclusion of others. Nobody can own a media outlet. Media is controlled by the Communist Party, unlike the previous one where it is controlled by the state per se. Here, the state itself is controlled by the Communist Party. So the Communist Party controls media outlets. The only difference is, in the authoritarian theory, media is used to perpetuate a status quo. In communist structures, media is used for change. It is used to effect changes in the society in tune with the communist ideology, that is to achieve a classless and a stateless society. But again, there is no media freedom. You and I don't have a choice, media choice. So why? Because the state acts as a guardian of the people. Because there is a presumption that you and I are incapable to take our decisions regarding our media choices. So what we want to consume as media products, we cannot decide. The third is libertarian theory. The best part of libertarian theory is that there is complete freedom. And there is innate faith in individuals' ability to take decisions regarding their own media choices. I want to watch something, I want to broadcast something, there is complete freedom. If I want to start a new media venture, I'm free to do that. But this theory is mostly followed in highly educated and economically advanced countries, because only then you can exercise this kind of freedom. Otherwise, it's possible. The drawback is the goal itself, the objective itself is to achieve highest degree of media freedom. Freedom itself is the objective. But why do we need freedom? That's not very clear. We need freedom. That's very clear. So the drawback is that when everybody exercises this freedom without bothering about the rest of the society or members of the society, in particularly multi-racial, multi-religious societies, they end up hurting each other's religious sentiments. So most of us are aware about the Charlie Hebdo incident in France, where some members of a particular community, they were hurt so much that they picked up guns and killed several journalists. Why? Because media is completely, oblivious, or rather deliberately, they don't want to bother about somebody's religious sentiments or this sentiment, that sentiment. They are saying that I have freedom, that's it. German philosopher Hoffel said there cannot be any rights without there being corresponding obligations. So rights and duties, they go together. It cannot be that all the rights I have, but I don't have any duties. The last theory, which is social responsibility theory, is considered to be an improvement upon the libertarian theory. Why? Because here the key point is freedom comes with responsibility. Means there cannot be any freedom without there being responsibility. And this is what we follow in India. This is also in tune with our constitutional framework, which gives us, which rather recognizes our right to free speech. At the same time, which authorizes the state to impose certain restrictions, reasonable restrictions, in the interest of sovereignty and integrity of India, security of state, blah, blah, blah. There are 7-8 grounds. So the entire issue of regulation of media, not just OTT platforms, be it the mainstream news media, be it television media, be it social media, the entire issue, or even films, the entire issue of media in whatever form, be it news, entertainment, social media, or any other media, it has to be understood in the context of our constitutional framework. That is one. And second, theoretically, we have to follow this social responsibility theory, which, while recognizing that we all have right, it also says that we also are obliged to follow certain norms. So freedom comes with responsibility. There cannot be freedom without there being responsibilities or duties. And that is how the entire issue of media regulation has to be understood. Now, unfortunately, what has happened is post-liberalization, market forces are very aggressive. I'm not saying they should not be, because they're supposed to sell their products. They're supposed to products not necessarily in terms of goods, but also in terms of services. And the Supreme Court has recognized their right to propagate this. And there was a time when the Supreme Court said in the 60s, in Hamdard Dawa Khana case that commercial free speech is not protected under Article 19(1)(a). But by the time liberalization came in the early 90s, in 1995, the very same Supreme Court recognized that commercial free speech is also covered under Article 19(1)(a). I suppose that was Tata Press case, MTNL versus Tata Press, 1995. Incidentally, or rather interestingly, in the same year, there is Supreme Court verdict in Hero Cup case. This Ministry of Information and Broadcasting versus CAB, Cricket Association of Bengal. That case is perhaps the first time that the Supreme Court pointed out that there is a gap between law and technology and the state needs to act. When I said that there is a gap and there has been a gap and the executive and the legislature, they have been suffering from some sort of policy paralysis and they have been caught napping. This was the first time. Television and radio, they were with the government. The government was controlling them. The radio, particularly news radio, is still in the control of the government. Because FM licenses have been given to private players, but only for entertainment and rest of the things, not for news. But television, when the government allowed private television to mushroom, even before that, the Gulf War I, when US invaded Kuwait and Iraq. Well, Iraq had invaded Kuwait and thereafter US forces invaded Iraq. Since then, cable TV is in India. The government didn't know. And all major cities, people had cable connection. And cable connection and people were watching news without there being any regulation. So without the government knowing it, cable television had already arrived in India, not just news but also entertainment. So the government in the 1995, the rules were framed in 1994 because first the ordinance had come and thereafter the Cable TV Network Regulation Act came in 1995. But the rules are still 1994. Generally happens that first the act comes and then the rules. But here rules came first because there was an ordinance. What happened was this Cable TV Network Regulation Act and the rules, they are the first time they exposed the incompetence of the entire system. They framed the rules. First they were caught napping, but then they tried to catch up with the technology because technology has already changed everything on the ground. When they tried to frame the rules, look at the non-application of mind. They put entire burden on the cable TV operators to ensure that the content is in tune with the requirements of Article 19(2), which is that it must not violate sovereignty and integrity of India, security of state, friendly relations with other nations, contempt of court, defamation, public order, incitement to an offence, and like that. It was for the cable TV operators to ensure that the content which is we are able to watch sitting at our homes is in tune with Article 19. And what is the role of cable TV operators? Somebody else is creating that content and via that cable it is reaching our homes. So what is the mechanism that a cable operator would have to regulate that? There is none, or there was none. But still it was for the cable TV operators to ensure that. So this is how our entire regulation has been. But leave it at that. Thereafter, Vajpayee government gave permission to private television channels to offer news. It was certainly a very good move and the kind of expansion we see in the entire television industry. Because of that, and we have, today we have around 1,000 TV channels, almost half of them new channels because of the diversity we have. In every state we have 5, 6, 10, 12 channels, regional channels, apart from the national ones. And that was a good move, but here also the government put the cart before the horse. They allowed the television industry to enter the news area without there being any regulation. And they are still struggling to have regulation. The industry would say, no, we want to self-regulate. The government would say, we want to regulate you. Sometimes the courts would say, no, this content is like this, and the court television channels are very aggressively saying, showing some certain things, and the content is not in tune with what it should have been. Unfortunate part was that even the Press Council of India does not have jurisdiction. They could have amended the PCI Act, added a provision that they would also regulate the television industry. They didn't do that. The result is that still we are debating whether there should be self-regulation or the government regulation should be there. Self-regulatory bodies which have been set up by the news media, television news media, they are divided. So they will have one body, and then another group will have another body. So this kind of the only area in which self-regulation is still working and very effectively is the area of advertisement, where Advertising Standard Council of India, you will never see any dispute or any negative publicity regarding that. Perhaps that's the model which can be replicated. But television industry, again, this debate is going on. Every time the government says something, the media industry would say that the government is trying to muzzle the press. And because of the emergency which happened in the 1970s, the government is on the back foot. The moment you say the government is imposing undeclared emergency, the government is on the back foot. So regulation of media has been a very tricky issue for the government. And most of the governments, they don't want to get into that because of the adverse publicity. And that makes the task all the more difficult. But so far as OTT is concerned, see, there are certain benefits. When we discuss OTT, the benefits is like if you go for broadcast, be it radio or television, it's very costly affair. But OTT, because of the technology involved, it's very cost effective. Market forces, they have been trying their level best always to directly reach the consumer. So OTT is, in the previous session, some speaker said in Marathi, that is the necessity is the mother of invention. So necessity is the mother of invention applies here also. The market forces wanted always to sell their products directly to the consumer, that is you and I. So if we receive everything in our phone, which we all the time we are having with us, it becomes very easy for them to sell it. So they have done away with all the intermediaries. There is no cable TV, there is no television, nothing. It directly reaches our phone, and while sitting, while moving, while maybe at times most of us watch while sleeping, before going to bed, anytime. In the morning you get up and start seeing something and you start watching. Sometimes there is binge watching. So what has happened is because of this attempt by the market forces to sell their product directly to the consumers, they have somehow invented this OTT, which is very, very cost effective. It is very, very accessible. All the time we are having it. We are not carrying our television sets, even if it's very small, with us all the time. And second is because of the fact that generally we can watch it in private like this. The content, or rather the quality of content, the nature of content has changed. It is not always like, suppose there is something which we are supposed to watch in a cinema hall, or maybe we are watching in our living room where the family is there, some children are there, some maybe elderly people are there, 2-3 generations are there. So we will be generally very conscious of the nature of content which is being consumed by us. But because of the nature of viewing, which is in private viewing, individually you are watching. So the content, you will see that generally it is there is sexual overtone which has increased in OTT platform, and this has given sort of boom to the entertainment industry. And in good old days, nobody would have thought that this kind of content would be watched. And in many at times you will see that some incestuous material is broadcast, or it's there on OTT platforms. So this is apart from being easy, cost effective, and anytime it's available, anywhere it's available. The negative point is that the content is generally, so far as quality is concerned, the selection of topic is concerned, there is a sort of, we'll see, you can say that there is a sort of cultural degeneration. I'm not not trying to be judgmental, but all of you must have watched content on OTT platforms. Generally, you see that there is a decline, which is very, very perceptible. You can easily see it. And also, sometimes the topics which are selected, not just forget about sexual overtones, sometimes deliberately very controversial topics. Controversial from the point of view of society, controversial from the point of view of politics, controversial from the point of view of caste or community relations. Sometimes, so there is a threat. Sometimes some religious issues are chosen. So there can be some content which can lead to some sort of violence. So media needs to be regulated. Why? Because as a society, as I mentioned to you, we exist, we need media. As I told you, media's role is important to inform, entertain, educate, to set the agenda for debate in the society. We need to discuss issues, and we also need to, as media organizations, individuals, we also work as watchdog for the society. And as the case is in India, media is, we are not an authoritarian society, we are not a communist society, we are also not following the libertarian theory where everything is free. We are following what is known as social responsibility theory, and there is, the right has been recognized, and at the same time the state has been authorized to impose certain reasonable restrictions in the interest of the 8 grounds I have mentioned. So this issue, at the intersection of society, constitution, state, individual, which is right of privacy is involved, various communities. So this is a very, and then apart from that, as I mentioned to you, the market forces, the consumer. As individual, I am a member of the society also. As individual, I am also a citizen of this state also. As individual, I am also a consumer. So when the media is trying to give us something at some platform, in this case OTT, I am receiving it in various capacities. As a citizen, as a member of society, maybe as a member of a particular community, and also as a consumer. Those who are approaching us, not always their intendings to earn profit. There can be cases where certain content is there on OTT platform with ulterior motive. It can lead to some communal tension. It can lead to some other problems. So while doing this, the state has to be very careful because of the fact that the state is supposed to ensure that media freedom, that is a fundamental right, that is maintained. Also, important, why media freedom is important? Because look at the world map and the societies across the globe. The societies which have maximum freedom, they have progressed the most, be it in the field of science, technology, art, culture, all sorts of fields. And societies which have given least freedom to their members, they are the least developed society. And sometimes maybe it looks that economically they are very advanced, but as a society they have not advanced or they have not reached that stage. And people will feel very suffocated. We are lucky that we are in a country where there is freedom, and the only thing is, when it comes to regulation, the government, successive governments have been very poor at regulation. Maybe I would question their intention, because the governments are very circumspect and they want to ensure that there is media freedom. So least regulation they have provided. But given the fact that this entire area is very volatile, given its possibility of misuse, there is a need for regulation. One, I'll come to the regulation which was announced last year. But the government, successive governments have been very poor at media regulation. Look at the Press Council of India Act. The first act was repealed during emergency, and thereafter the second act has come, and which is the current act. Press Council of India is known as a toothless tiger. Why? Because that's a different thing, that is headed by former Supreme Court judge, barring the first Press Council of India chairperson. All have been former. Otherwise, the first one was the sitting judge. The Press Council of India is known as toothless tiger. Why? Because it doesn't have any powers. It has powers only to censure or any newspaper or reporter or editor. Nothing else. It cannot punish anybody. I have attended Press Council of India proceedings several times. Nothing. I'm not saying there should be harsh punishment, but if a newspaper or a reporter or an editor have been indicted by the Press Council of India after proper hearing, in which media representatives are also there, then there has to be some sort of, if not punishment, I'm not saying somebody should be sent to jail. At least there should be provision that you publish the indictment on your in your newspaper on page 1. Even that cannot be ensured. So media regulation has been weak. I talked about print, electronic media. I said we are still struggling with regulation. The two of the bodies that have been set up for regulation of television media, news media. A few years back, a particular TV channel, I did not write the name, was part of that body. And when it was indicted and asked to pay a fine, it walked out. He said no, walked out. He said no, we are not part of it. So this kind of attitude, I'm not going to comment on any of the TV channels. You watch TV channels as if everybody is angry and everybody is shouting at each other. So a sort of insanity you will see. So regulation is a must, first thing. Second is whether there should be a government regulation or self-regulation. It's a very tricky issue, but I have a solution which is via media. Via media in the sense that whatever self-regulatory body that industry sets up, just have one government representative, because government is a necessary stakeholder. In the absence of any proper regulatory mechanism, what happens is the government is left with only one option, that is to invoke the licensing condition. That is for television industry. So I am saying if you have a self-regulatory body, no problem. Have one representative from the government. And thereafter, that self-regulatory mechanism must have a statutory backing. Why? Because in case of violation, or somebody is saying that we will not obey, some sort of punishment must fall. In the first session, some speaker mentioned about Austin. Law is the command of sovereign, backed by sanction. Without there being sanction or punishment, nobody is going to obey law. So this self-regulatory body can be there, but there has to be at least one government representative, because the government is necessarily a stakeholder. One. And then that self-regulatory mechanism in which I am saying add one government representative, it must be given a statutory backing so as to ensure that in case of violation, we can actually have a sort of guarantee that that particular player or TV channel or whosoever is would be punished. There have been various other organizations. I mentioned to you about television in BSA, and there is another body, Press Council, I have already mentioned. There is CBFC, which is about films, and there is also Internet and Mobile Association of India, which also regulates this internet-related field. And then Digital Curated Content Complaints Council is there. So there are various bodies. So far as OTT is concerned, OTT, there were 2-3 important points which we need to understand what the government announced last year. First was putting a sort of onus on the platforms that they will self-classify the content. Otherwise, anybody can show anything. And that classification was based on age. That is, there was, I suppose, if I remember it correctly, there are 5 classifications based on age. One, of course, is universal, which we all know. But then 7 plus, 13 plus, 16 plus, and then 8. And apart from the universal one. So this was, first was having age classifications and self-classifications by the OTT platform. Second was regarding having parental locks. Suppose something is classified only for viewing of, say, adults. So parents would have locks. If they want, they can lock them. Then the controversial part was that they are supposed to follow the Cable TV Network Regulation Act and the rules, and they are supposed to adhere to the Code of Ethics. And the Information and Broadcasting Ministry will also form an oversight. It will form a panel, and there will be an oversight mechanism. And because this OTT platforms, the rules were also for social media, and social media was one of the important points was the first originator of the content, particularly where the content is considered to be anti-national or something. They were supposed to identify it. And this is where social media platforms had some problems, and Twitter was throwing tantrums in complying with that. OTT is slightly different from say social media platforms. That's a different thing that both have access to our mobile, or we have access to them through our mobile. Social media platforms are slightly different in the sense that the entire content is user generated. What in technical terms, it is also known as UGC, user generated content. not the university grants commission. And it's because the entire content for social media I'm talking, is generated by the user. The platform doesn't know what content has been generated and it's there available. So because of the fact that the number of users are in millions and every second huge number of information is being generated, there is no mechanism for the platforms to regulate that. So because of this, and they are not generating it, they cannot have what in journalism we call it editorial oversight. What you see on television, news, there is of course editorial oversight. There is an editor, there is that setup where it's vetted at various levels. In print, the vetting is much more rigorous, and because they have time. So whatever happens today, when at this hour, you will get it tomorrow in the morning. So late in the evening till maybe 12 midnight or past that, the editors have time to check, cross-check, verify and correct it. But in social media, everybody is in a hurry. So immediately everything has to be put out. And the platforms don't have any mechanism. That is why under the Information Technology Act, Section 79, there is exemption given to intermediaries. It's known as safe harbor clause. But OTT platforms are a bit different in the sense that you actually have content which is prepared and then it's released on the platform. So it's slightly different from that. But OTT platforms have to slightly treated on a slightly different, in a different manner from social media platforms. And the government's attempt to regulate them. One thing is that the government has this regulation which is for both of them, which is, I would suggest that OTTs should have a separate regulatory mechanism. And any mechanism, even if self-regulation, which the government has prescribed, it must have a government representative. And then, instead of framing rules under IT Act, I would rather say, I'm not saying that IT Act is not sufficient, despite the fact that there are several lacunae in the IT Act. But IT Act, not many people know. IT Act was primarily brought in to give a fillip to e-commerce, e-governance. It was not meant to regulate OTT platforms or news media. So I am saying there has to be a separate law, a separate regulatory mechanism, everything separate. Because IT Act, in fact, there has been demand that since the critics say our IT Act, Information Technology Act, is the most cyber crime friendly act. Many countries have enacted separate IT laws, information technology laws, to deal with cybercrime. In India, the law was primarily enacted following United Nations General Assembly resolution to give fillip to e-commerce, e-governance. So purpose was something else, and the cybercrime part you see is just a byproduct of the main act, the main purpose. So I'm saying there should be a separate law to deal with cybercrime, that's one, and separate law to deal with entire gamut of media, which is new media. In fact, the one is traditional media, which is print, and you can say the electronic media, which is television, radio. The new media, which is primarily governed by this internet, which has been declared to be a fundamental right in Anuradha Baseen's case in January 2020. There has to be a separate law, particularly because the Supreme Court has declared that it's a fundamental right. Then the government should come up with a separate law, and that law, while recognizing that verdict and they write, this would prescribe certain regulations. And there has to be consultation with all the necessary stakeholders. And of course, this is part of the consultation it can be treated, because whatever we discuss in public domain, and this is how democratic societies function, before any decision is taken, there's a whole lot of debate, discussion. Even after the government prepares the draft bill, it is generally put out on the website, the ministry concerned, and then people are free to comment. The law commission invites comments. So this is how the entire issue needs to be understood, debated, discussed, and then the government should come up with a separate law or regulation to deal with all entire issues, all the issues relating to the new media, in which you can have two segments, OTT and social media can be separate segments. But there has to be a separate sort of law and separate set of regulations for the entire OTT platforms and also social media. Else, because of the fact that media is also prone to misuse. And it can be misused in today's days to somehow instigate one community against the other. It can be used for various other purposes apart from the kind of serials we see, or seasons, various issues, and generally there is decline in the quality of content because of the fact that people cannot think. Creativity, people claim creative freedom and they want creative freedoms to be protected. But the fact is that we hardly see any creativity apart from barring a few. And generally there is what we witness is cultural degeneration, the kind of topics we select. So that's a different issue, and as a society we need to think about. But so far as regulation is concerned, one is regulation has to be there. Second is any regulation, even if self-regulation, it has to have at least one government representative. And finally, any self-regulation, it can never work unless it is backed by any statute. Thank you very much. And if you have any questions, you can.
Can we have the lights, please? One light here. All right. Thank you so much, sir, for throwing light on various topics.
Am I audible?
Yes, sir, certainly. Our voice is audible to you?
Yes.
All right, sir. Thank you so much for throwing light on various topics, discussing benefits of OTT and also discussing negative factors in relation with the content quality and selection of topics. And of course, the valid point what we have discussed here is the need of regulatory body in terms of new media. So thank you so much for letting us know the right way and clarifying our thoughts, sir. So any questions do you want to ask to sir? We are going to take 5 questions over here. Okay, we have 2 questions.
Right to watch pornography in private. Right to watch something which involves abusive language. If it is watched in private, I don't see, so far as legal aspect is concerned, any problem. But as I mentioned to you during my presentation, see, this is not just an issue relating to law. There is law and constitution. There is society, there is individual, there are market forces, there are individuals as consumers. So the entire gamut of things, and it's a very complex interplay between various players and various interests. So coming up with a regulatory mechanism, so one aspect is ensuring that nobody's fundamental rights are violated, including right to privacy. But there is another aspect of the larger aspect of cultural degeneration. What kind of society we want to become. So that has to be thought, debated, discussed, and accordingly regulation has to be framed. Because the problem is, in good old days, we were a society based on duties. Everybody was bothered about his or her duty. Like Lord Rama was asked to go to Vanvas, so he was worried about his duty as a son. So he did not question anything. He straight away went ahead. But today, everybody is worried about rights. And we are, not just in India, there is something called rights-based approach. So we are enacting laws and laws and laws and then creating various rights. But what about duties? As I mentioned to you about Hoffel, the German jurist, there cannot be any rights without there being corresponding duties. So with duties, unless we think about, it will be very difficult. So one thing is that legally it is a very tricky question. It says that right to privacy is a fundamental right. So somebody is watching pornography or abusive language used in a particular serial or something. It is his or her fundamental right. Second is, as a society, we need to think the quality of content and general degeneration in such things. Should we allow it? And how far societies or societal interests, the larger interests of the society, can affect an individual's right to exercise his or her personal choices regarding certain media products, whether I want to consume this or that. So as an individual, whatever rights I have, can the society and the state representing the society interfere with that? So there has to be a proper balance between that. But this question has become much more relevant today.
Thank you so much, sir, for answering that question. Do we have any more questions?
In my home. As parents also, we are supposed to exercise some due diligence. Everything cannot be left to the state and regulatory mechanism. So these are some aspects which we are supposed to regulate. Children, particularly children who are, say, not who have not reached the age of 18, they are not living alone. They are living with their parents or maybe near ones, guardians. So as parents, we are supposed to exercise due diligence and keep a watch. Like in my home, no laptop, barring mine, no laptop is allowed to be installed at a place or put at a place where others cannot look at the screen. Both my children, their table is such where everybody can, sitting any part of my house, can watch that, what is there on the screen. So as parents also, we have certain duty, and we cannot delegate this duty to the state or any other regulatory body. So this part has to be handled by parents.
All right, this was the last question of this session. So thank you so much, sir. We appreciate your presence. Since it was online session, please accept our sincere